Yeah, please. I beg to mention item number 17, my lord. In this case, my lord, today we have filed an additional affidavit.
Item number 7.
17, my lord. 17, my lord.
17.
Yes, my lord. Please for the respondent, my lord. Today we have a report.
Arjun. Yes.
Hello, please. Yes.
Item number 19 is the type. Item number 28 to 25.
Wait, please, your lordship. Your lordship, like you mentioned, item number 29, your lordship. Can it be on Friday, your lordship, next, your lordship? My senior was supposed to appear, however, he is traveling today. This way. Can it be on Friday, your lordship? My request, your lordship.
Early listing application is 28, actually, 29.
29, your lordship.
First week of June.
But then it may be taken today, itself. I beg pardon if your lordship.
Okay, fine.
Maybe today.
Okay.
May I please, your lordship? Lordship, kindly item 37, kindly adjourn for the day, lordship.
37.
37, yes, lordship.
There are many matters. There are connected matters are also. Connected matters also listed earlier.
Yes, lordship, but my senior is out of vacation today.
Have the numbers,
He is not.
similar matter. A model college na Tara Godina, model college.
Justice Manish Chaudhary does not.
Monitor.
Several.
IP Kotogi sir and D Mojumdar again.
Yeah.
Right, sir.
List along with so and so. At the request of land council.
May I please, your lordship, lordship, with the consent of the other side, I beg to mention item number 40. 40.
The term is over once it is, this cooperative societies with
43 and 39. That period is
period is over. Adjourn. Yes.
May please, your lordship. Lordship, with the concern on the other side, lordship, I beg to mention item number 54, your lordship. Lordship, I'm paying for accommodation for today, your lordship. And on the request of the respondent side, lordship, they are requesting to fix a date. 54.
It's a hearing. Adjourn.
Much obliged, lordship.
Big please, your lordship, with the consent of the appellant government of state of Assam, lordship, I beg to mention item number 34, lordship. I'm for the respondent, lordship.
34.
34.
34, yes, lordship.
Suspension, retention.
Condition that any provincialized no, they were given.
Adjourn.
Obligation.
List for orders, item 1 to 3.
Unnecessary.
Yes, yes, so, so today I am filing it, my lord.
So today I'm filing, what do with this? Today I'm filing, what do you mean by today I'm filing?
My lord, due to my mistake, my lord, I could not file on time, my lord, because I have,
Otherwise, my lord, there is no merit in this case, my lord. Because, my lord, honorable single just, my lord, pass order, my lord. Rightly pass that order, my lord. The rule of game has been changed.
What is the report of service?
my lord, here, my lord, I have sent to the director of elementary education, my lord. They have tried to serve it through the district elementary education officer, but they have refused to accept it, my lord. But
What
unfortunately,
is
my
the
lord,
refusal?
unfortunately, they have sent it to through by speed post, my lord.
Speed post is-
The speed post, even though delivery of the speed post or refusal by the party concerned? What is this service?
That is, my lord, that is why I just want to bring it on record by way of an affidavit. There is no,
What do you mean by affidavit? Where is the proof of service of notice that they have refused?
my lord, that the notice, my lord, they have sent it through speed post, my lord.
Speed post maybe there must be some, there is some mark on the speed post that they refuse to take this.
That, my lord,
Affidavit is filed on behalf of the Standing Council of the Education Department regarding service of notice upon the answered respondents. However, from the said affidavit cannot be concluded that the notices have been served upon the answered respondents. Let fresh notice be issued to the answered respondents. What's the matter about?
One advertisement published, my lord, for filling up a post of assistant teacher, my lord.
That although if you have written the paid post, there is no certificate that is being reported. It is that is.
Advertisement page 41,
Government.
notification page 18.
Mr. Das. Certificate is. 45. Only for this distance. This is a certificate. Scheduled distance. Username of basic.
Yes. Can last one? Fresh notices be issued to the answer respondent to register dating because it's filed within a period of 1 week in filing of the same. Let notices be issued to the answer respondent to register date.
Bloodless.
Item 4 to 7.
Lordship, I am appearing on behalf of Mr. B. Patek in this case, my lord. We have received the instruction from the department, only 1 week time may be granted to file the affidavit, my lord.
Compliance.
Affidavit for what?
Then, as per the last order, my lord.
The last order, you have already filed affidavit pursuant to the last order.
Lordship, we have filed an additional.
9/4/2024.
Against the additional affidavit. my lord.
This 9/4/2024. That affidavit is already there.
I think the additional affidavit have been filed by our lordship in item number 6. So he will be filing reply to that additional affidavit.
But that affidavit is already there in 9/4/2024. You are for the state.
Stay is for the.
For
BSNL.
BSNL, my lord.
Kerala for the particular. They have brought.
Sorry, sir, it should be 4 to 7.
Krishna, you cannot be sitting here and
So then you feel the something, it will be figured as now. Repeat. Continue for the. Yes, yes, is a general thing for every labor. But if they go for this provident, first provident, they will be not about the first provident. I think here for then first, then pension. But one thing, first would be even if this is now. So we have now with the name of the. Years and that has been done. Only thing they have not been paid them. But in the party. This would be an issue because.
Let me consider the respondent state. Praise for, the respondent BSNL prays for some time to file counter to the affidavit dated 9/4/2023. Some errors were filed by the petitioner.
Deeply, your lordship.
Obliged.
Seven is also same by. Seven is also same by. What?
What do you think?
Seven or?
No, four, five, six, seven.
Seven. Fine.
Is
Four.
Item 8 to 10.
Another case, the principal and the interest was, there is no order. This will go through the payment of vehicles. To be paid to the. This is an item number. Eight. There is an interest component of.
interest amount of rupees 10 rupees deposit amount in connection with this.
This is 371. 120, that will come in the second. Second, there was no direct. This is for the first item, item number 8.
Upon for consideration of a note placed on behalf of the Registrar General, Guwahati High Court. Is stated in the note that while disposing of Writ appeal number 199 public 2019. Writ appeal number 199 of 2019. The division bench of this court has ordered that the amount of rupees 3,51,187 be deposited under the Payment of Wages Act, and on deposition of the same may be transferred to the concerned
Payment of wages.
concerned authority under the Payment of Wages Act, so that it can be dispersed to the concerned workers or to their legal heirs, to the concerned workers or to the legal heirs under the Payment of Wages Act. It stop as per the note, the said amount has been deposited. And therefore, is state that the Assistant Labor Commissioner come authority, Ulubari, Guwahati, be directed for taking steps to receive the amount of rupees 3,51,187 from the registry. Along with accrued interest on the said amount. In such circumstances, let notices be issued to the Assistant Labor Commissioner come authority, Ulubari, Guwahati, returnable on which day? Returnable on 10th of June.
I may represent the Assistant Labor Commissioner.
In such a manner, we deem it appropriate to issue notice to the Assistant Labor Commissioner Ulubari. The Assistant Labor Commissioner come authority Ulubari, Guwahati. Mr. So and so accept notice on behalf of the on behalf of the said authority.
Jackie.
He
Item
prays for
number
and
9.
directed a week's time
Number 9.
to move appropriate application as per the above direction.
So,
The registry may be directed, my lord, to communicate this order to me.
We pass this order in your presence, again you are seeking a communication.
But there was another amount. That is 1,23,000. Same. Only amount was. There was no earlier.
The note. And the matter comes upon for consideration of a note placed on record through the Registrar General, Guwahati High Court, with the prayer to issue direction to the Assistant Labor Commissioner come authority Ulubari, Guwahati, for receiving the amount of rupees 1,22,010 rupees and the accrued interest amount rupees 3,711 pursuant to the order passed by this court in writ appeal number 203/2019. Full stop. Taking consideration of the note, we deem it appropriate to issue notice to the Assistant Labor Commissioner. Assistant Labor Commissioner come authority, Ulubari, Guwahati. Mr. So and so accept notice on behalf of the state. He waste some time. If he to know appropriate application on behalf of the said authority. Stop ready.
Same.
This date,
June 10th. For my day. Next week.
next week. We will.
Yeah, like a 10 week before the.
तीनों का common order है.
Item 11,
Subsequently. Infractions. Sounds like that. We can go to banging into the ring.
The matter comes upon for consideration of a note. This note of the Registrar General Rajasthan High Court placed on record. Seeking direction from the Honorable Court regarding the disposal of the amount of rupees 50,000 deposited by the petitioner pursuant to the order passed by this court in WPC number 4472/2020 dated 3/8/2021. No, sorry, order dated 2010/2020. Full stop. The petitioner has filed the above referred writ petition being agreed with the auction notice. The auction notice dated 18/9/2020 issued by the respondent bank. Full stop. This court by the order dated 2010/2020 ordered that the e-auction notice dated 18/9/2020 comma, even if carried out, comma, shall not be given effect to without deed of this court, comma, however, subject to the deposit of rupees 50,000 by the petitioner before this court within 3 days. Full stop. The said amount was deposited by the petitioner within the stipulated time. However, the writ petition came to be dismissed as infructuous on 3/8/2000. However, the writ petition number 4472/2020 was dismissed by this court as infructuous on 3/8/2021 without giving any direction regarding the disposal of the said deposited amount of rupees 50,000. Full stop. Taking into consideration the above facts and circumstances of the case, we deem it appropriate to issue notice to the petitioner whether she is interested in receiving the said amount, the deposited amount or not. Registry is directed to issue notice to the petitioner returnable on 10th June. Yes, thank you.
Item 12,
My lord, well, here is the office note dated 30th April office note, my lord.
ये नोट को
Note that they have deposited.
amount it's a
You are for the,
I'm the appellant, my lord.
you are the appellant
And I have deposited the amount, my
and writ petition was dismissed with cost.
my lord.
Writ appeal was dismissed with.
Yes,
cost.
My lord.
Well, last, the
Legal-
deposit the cost in this. Assam
I have
state,
done, my lord.
Legal
I have done,
legal,
But
legal,
that deposited amount will use for the Assam Legal Services Authority.
my lord.
The matter comes upon for consideration of a note placed on record through the Registrar General Rajasthan High Court, wherein a direction is sought for the disposal of rupees 25,000 deposited by the appellant pursuant to the order passed by this court on 29/11/2021. Stop. This court in writ appeal number 319/2021. Decided on 29/11/2021, comma, while dismissing the writ appeal filed by the appellant has imposed a cost of rupees 25,000 with the direction to deposit the same within a period of 2 weeks. Full stop. Within that stipulated time, the cost was deposited by the appellant. Stop. Since this court has imposed the cost upon the appellant, treating the writ appeal as frivolous, treating the case filed by the appellant as frivolous, we deem it appropriate to direct the Registrar General of the Rajasthan High Court to deposit the said cost amount in the funds of Assam Legal Services Authority, Assam State Legal Services Authority. With these observations, with these observations.
Our last.
Yes.
My pleasure, Lordship. The matter has come for orders, my lord. Affidavit.
Item 13,
Matter has come for admission. My lord, reading is already over. So matter may be fixed for hearing, my lord, admission.
This ground. In the last occasion,
My lord,
when the matter was adjourned, you sought some
yes.
time to argue the matter.
yes, my lord. But I thought, my lord, matter has come for orders. I'm not fully prepared today.
Sir, there is nothing to prepare in this matter.
My lord,
In fact,
even,
the appointment of the
My
government
lord,
was of 2000,
I understand, my lord, I understand, my lord.
2013.
Because,
And
my
the
lord,
learned single judge has dismissed the writ petition of
That's
the
true.
ground that since a long time has passed. Now, again, long time has passed.
my lord, Lordship kindly appreciate one thing, my lord.
Yeah,
The Lordship has to examine whether the appointment was made in terms of the, my lord, executive instruction, which was held to be binding, my lord. Therefore, my lord, there are three different parameters. One of the parameters was left out. And suitability is the criteria. Merely because of the fact that, my lord, somebody has secured the highest mark. The performance of mark or merit is not the basis. Division bench held, and that was ultimately gone to Supreme Court. And Supreme Court, my lord, upheld the decision of the division bench. And appellate court, my lord, has got the co-extensive jurisdiction, co-extensive power. Appellate court can access power for that of the selection process. And court was of the view that the order of the appellate court is absolutely cryptic
yes.
and should have been reason order. But we are not proposing to send it back to appellate court. And on the other hand, my lordship kindly appreciate that, my lord, parameter which was laid down in the executive instruction, does it have any binding force? And once one parameter was left out of three, my lord, member of the selection committee, two members, my lord, awarded marks equal. And one of the members who, my lord, awarded marks something more, my lord, as a result of which difference comes up to 5. And on the other hand, my lord, experience and views of the, my lord, local villagers are, my lord, required to be taken into consideration. That was not taken into consideration. Experience was also not taken into consideration. And ultimately, my lord, selection was made in his favor. Therefore, lordship will examine this question, my lord. I will cite some decision. Today I am not prepared because matter has come for orders.
Sir,
Of course, I have
that's
made a
why only-
commitment, my lord.
That's why only we are amused that you have not prepared the matter and argued thoroughly. And if you have prepared the matter, then it would be very difficult for us.
Well, I could have argued in a better way, my lord, provided I have a better preparation.
We are not going to interfere. Please try to understand. Yes, Like, this writ appeal is filed by the appellant being agreed with the order dated 29/8/2019 passed by the learned single judge in WPC number 6777/2017, whereby the writ petition filed by the appellant has been dismissed. Stop. The appellant, the appellant has raised a question regarding the appointment of the Gram Barua on 10/10/2013. Full stop. Gaon Barwa, respondent number,
That's not fine.
respondent number 5 on 10/10/2013. Full stop. The learned single judge, after hearing the counsel for the parties and after going through the record regarding the selection of the Gram Barwa, has recorded a finding that the marks awarded by the members of the selection committee to the respondent number 5 are higher than the appellant. The learned single judge has also observed that long lapse of time has been passed since selection and appointment of the respondent number 5. And therefore, no useful purpose would be served by remanding the matter back to the appellate authority, which would merely an academic exercise. Full stop. The academic exercise, because the court has found no error and infirmity in the selection and appointment of the respondent number 5. Having heard the learned counsel for the appellant, and after taking into consideration the fact that even after dismissal of the writ petition, almost 5 years have passed, we are not inclined to interfere in the matter passed by the learned single judge, hence appeal is dismissed.
On the ground of, my lord, delay. Basically on the ground of delay. Bless.
Item 14.
May I please the Lordship?
Yes,
Lordship, I'm a registered society and filing this PIL for 150 golden langurs in Bhairav Reserve Forest. Lordship, golden langurs are found only in Western Assam, in entire India. Only 50
respondent number 15 has not been served.
Yes. But I have filed an IA for some interim relief, Lordship.
Whatever it may be, first of all, once the notices have been issued, get the notices served upon the respondent number 15.
Lordship. Lordship, there is all possibility that stage 2 clearance may be granted, Lordship. That will.
So whatever it may
as per
be,
my
you
PIL,
get the notices served, we'll hear you.
Lordship.
Okay. As per the office report, the notices upon the respondent number 15 has not been served. Remain unserved. The notices issued to the respondent number 15 remain unserved. Learned counsel for the petitioner raise a week's time to take steps for service of notice on the respondent by registered post AD within take some time, registered post AD. A week's time is granted to do the same on furnishing, on doing the same, let notices be issued to the answer respondent number 15 returnable 3 weeks thereafter. Yes.
My lords, I appear for respondent numbers 13 and 14. We filed our counter affidavit.
Item 15.
F is a lordship. My lord, there is a order of the listener.
Appointment हो गया?
Lordship, it will be issued within a day or two, Lordship, at the final stage.
लिखिए learned counsel for the respondent. Mr. Learned counsel for the respondent, Mr. P. Nayak, has produced a copy of the communication dated 14th of May 2024, issued by the Deputy Secretary, Government of Assam, Irrigation in bracket establishment in bracket close department Dispur, and has submitted that the appointment order would be issued to the petitioner within a day or two. Stop. Place this matter on Tuesday.
Tuesday.
Produce the
Next Tuesday, yes, Lord.
Tuesday. or otherwise call the officer.
Only the CM's approval is there.
Whatever it
That is why
may
it is
be.
pending. Only that is the only, otherwise appointment letter is
Whatever it
also
may be,
ready.
call the officer. Yes,
Item 16.
Lordship, that item 16, I'm seeking a pass over for the timing, Manoj, Mr.
application for
Majumdar is-
condonation. On last occasion also, you have served time,
No,
155 days delay.
Malad, I am not in this case, Malad. R. Mujumdar was there, Malad. He has asked me to, thought he's legs in another court, Malad.
Who is the advocate?
R. Mujumdar, Malad. For the sole respondent, Malad.
So he is opposing this.
Right, right.
delay condonation.
Timing, Malad. File an
Pass over the
affidavit,
timing.
Lordship.
General.
Generally,
General.
what is the reason for filing this
Lordship,
delay?
paragraph 3, 4 and
So
5,
casual.
Lordship. I'll be relying on two decisions, Lordship.
So the opinion obtained also, the records of the case could not be immediately obtained. as the
In between,
because
there was
the
long
vacation.
vacation.
Lawyer chambers are mostly closed.
Too long vacation was also there in
Lock कर
between,
देते हैं क्या
Lordship.
पूजा vacation में लॉक ही कर देते हैं कोई नया क्लाइंट आता है, you are not supposed to entertain them. Can't be not a government office की lock it and go away from there.
Pass over timing, Malad.
Okay, pass over for the timing, ask him, we are going to convert the deal.
He's.
Item 18.
Issue the notices.
Same subject method.
Yeah.
This is Sipada Town Committee, Farupatia Town Committee, there is same case pending, my lord.
Pending, what's the number then?
And number I'll get, I'll give it.
List along with so and so.
Item 19.
Meet legal lordship. Lordship, we have taken steps by Dusty Lordship, but that is not yet returned. We will be allowed to take fresh steps, Lordship, by Dusty on the respondent number 1.
Then council, the notices upon the, and the notices issued to the respondent number 1 of the IA has not been served. till date. Then council for the plan. Place for and granted a week's time to take fresh steps for service of notice upon the respondent who registered ready.
Lordship.
On furnishing the same, on furnishing the particulars, let notices be issued to the respondent returnable 4 weeks thereon.
Obliged.
Item 20.
Legal lordship, there is a delay of 254 days in preparing the lordships.
How you explain the delay?
Yeah, explain this. Paragraph number 3 to 8 lordship, immediately after judgment of this learned single judge lordships,
Yes.
we preferred a review petition. Review petition dismissed lordships since the matter is re-hearing and should not be
What
entertained.
do you want to say?
Prefer.
No, my lord, I went up condoning that delay, my lord, I have no objection, my lord.
No objection.
No
Okay, the matter comes upon for consideration of the IA with the prayer to condone the delay of 200 and so and so days, 54 days in filing the connected appeal. Full stop. Then concept for the respondents has no objection if the delay is condoned. Having heard the, you are appearing for all the respondents?
My lord, only 3.
1.
Respondent number 3.
Respondent number 3, and what about the others?
Number 1. Respondent.
Respondent number 1.
Number 1 is the main
No,
lordship.
1 Ramgiri is the petition.
Ramgiri.
Ramgiri.
Ramgiri is main.
He is the main, he is the read petition lord.
He is also represented.
Anybody is appearing on behalf of it?
Yes, Mr. Case of Service, none to be carried. May have not been. One of the you got a business of some number 1 and 3. I think it's one have given 3 administration. Three administration.
It's a door.
Do. Help us. Last C help us. It's.
Okay, but now. Yeah. But who is the respondent?
Respondent number 2 is the government. Three administrative officers.
State of Representative Commissioner.
Performer.
Yeah, representative. Commissioner and secretary to the government of what's the Department of Labor.
Yeah, sir, real performer. Same office. Objection be made.
We are appealing for the respondent number 1.
Respondent number 4.
Respondent number 4 is there. Yeah, senior auditor of. Where is this K. Bhattacharya? K. Bhattacharya. He has filed Vakalnama on behalf of respondent number 1.
One and three person, दोनों का भी हाँ नाम तो है और ऑब्जेक्शन भी नहीं है.
The matter comes upon for consideration of the application number. So IA number so and so with the prayer to condone the delay of 254 days in filing the connected appeal. Stop. Power is filed on behalf of the respondent number 1 and Mr. So and so is appearing on behalf of the respondent number 4. Ms. So and so is appearing on behalf of the respondent number 3. Ms. So and so is appearing on behalf of the respondent number 4. Earlier, this R. Talukdar is appearing on behalf of the N. Das, junior advocate was appearing on behalf of the respondent number 2. Respondent number 2 is represented through junior government advocate Assam. Stop. No reply. And no counter to the IA is filed on behalf of any of the respondents. Having heard the learned concept of the applicant and after going to the contents of the applicant, we deem it appropriate to allow the application number so and so. Hence, the IA is allowed delay in filing the delay in filing the connected appeal. Delay of 254 days in filing the connected appeal is condoned. This matter for admission after 2 weeks.
Oblige.
Item 21.
Registry is directed to the registry the connected appeal and listed. Register the connected appeal and listed for hearing. Listed for admission after 2 weeks.
My lord, it is listed for first time, my lord. Again, the judgment date, my lord. 12/6/2023, my lord.
Push notice returnable 4 weeks. Registered AD.
Obliged.
Item 22.
Yeah, please, Your Lordship. My lord, this is an application for condemnation of delay of
First
99
time.
days.
This is the first time
No, my lord.
Notices have been.
notices have been issued.
He has already, my lord, step has been taken. Copy has been started with others.
Okay, my education elementary put in appearance on our behalf. You are appearing for
Yes, sir.
all the respondents. Yes,
1, 2 and 3.
Do you have any objection? The matter comes upon for consideration of the IA number so and so. With the prayer to condone the delay of 99 days in filing the connected appeal. No reply to the, no counter to the IA is filed on behalf of any of the, on behalf of the respondents. Having heard the learned counsel for the applicant and after going to the contents of the application, we deem it appropriate to allow the same. Once the IA number so and so is allowed, the delay of 99 days is condoned. Registry is directed to register the connected appeal and to list for admission after 4 weeks.
Item 23.
May I please the lordship? Filed as per office note dated 13/5/2024 services incomplete upon respond number 1.
This is great.
Await return of notices for 3 more weeks.
Item 24.
It's 9/4 issue. 24. 9/4.
Same time.
Await return of notices for 3 more weeks.
Item 25.
In this case, I am appearing for the respondent number 1.
We are appealing for the respondent.
Therefore, 4 days time, you have to find my objection.
There is a delay of
42 days delay.
Petitioner wants me, he is a retired person. He has not been paid his pension.
Certainly get your, this, whatever the controversy decided, why you are taking time for this formalities of filing objection and all? 42 days, we are otherwise going to condone.
Let it be fixed then for admission hearing.
Yeah, sure. The matter comes upon for consideration of the IA number so and so with the prayer to condone the delay of 42 days in filing the connected appeal. Full stop. Learned counsel appearing for the respondent, sole respondent as opposed the application. However, having heard the learned counsel for the parties and after going through the, you are appearing for the
sole respondent.
sole respondent.
So, respondent.
However, having heard the learned counsel for the parties and after going through the contents of the IA, we deem it appropriate to condone the delay of 42 days in filing the present connected appeal. Hence, the IA number so and so is allowed. Delay of 42 days is in filing the connected appeal is condoned. Registry is directed to register the connected appeal and listed for admission after when?
After 2 weeks, no?
After 2 weeks.
Much.
Item 26.
And for the-
29/4.
Await return of notice for 4 more weeks.
Item 27.
Wait, please, Your Lordship. Delay condemnation petition matter coming up for the first time.
First time, 35 days.
35 days.
Issue notice returnable. 4 weeks registered ready.
All right.
Item 28.
Early hearing application.
Yes.
Who is appearing for the other side?
Other side, the government actually, they prefer an appeal against the order passed. I should have been here. They filed an appeal against the order passed by the learned single judge. Learned single judge.
Yeah.
But the order was stayed by the learned division bench only on the ground that we didn't comply because there was a time when it was moved. There was a interim order passed that you immediately joined. We did not join. That's the division bench got annoyed.
The matter come, this IA.
Yes.
So and so is preferred on behalf of the respondents
Yes.
for early
Right.
listing of the writ appeal number 336/2023, full stop. Having gone through the application, we deem it appropriate to list the list the writ appeal number 336/2023 when?
It's May, June also.
11th of June.
11th of. Well, one additional affidavit we have already filed. We have filed an additional
That
affidavit.
will come on the,
Only
that in
one
appeal, na?
request,
You have filed that additional affidavit in appeal.
we have filed an additional affidavit in the appeal.
In appeal, so the appeal is not listed today.
Yes, yes. Just one request, my lord, when the appeal was filed, this appeal it was not a complete appeal they have filed. Some reply I have filed, these are not being brought notice when the appeal is filed. So at least they
when
should
the-
file.
Sir, in this, how can we direct all these things?
No, this, I'm just telling because my learned friend is there.
Yes, Mr.
They should come up
Take
with,
note of this.
Yes, yes.
What they may come up with this objection at the time of hearing of the appeal, take note of
I'll
it.
file additional affidavit.
Whatever it may be.
what was,
Additional affidavit need, what they are saying, you have not supplied all the documents.
all the document they did not file before the court.
That's right.
Yes.
Take note of it and do whatever is required.
Yes. I'm deeply obliged, man.
Okay.
I'm deeply-
Pass over matter 16.
Oh, the. Honorable Jindal.
Yes. You're objecting to it.
My lord, I'll have only two objections, my lord.
What objections? Yes.
My lord, the appeal was filed 155 days delay and thereafter there was 180 days delay in correcting the defect, bringing the total delay to 360, more than 360 days is one part. I was terminated from service because I reported late by 160 days. I go hungry, my lord, their contention. But the delay of 155 days, they say should be condoned.
Consider at the time of this hearing of the appeal.
My lord,
We'll consider this,
My lord,
whatever
if-
your argument at the time of
my lord,
hearing of
the
appeal.
explanation given by them is that it was festive mood.
Is that,
Maybe that can be
yes,
condoned.
I have already confronted him that
My
he
lord.
said office was closed for vacation.
Madam, the office was closed for total 20 days. The delay is 155 days.
Even 20 days office was not closed.
It was
in
otherwise functional. Our
Otherwise,
court said
sometimes
holiday.
If the new, if a new litigant comes, so advocate will say, no, the office is closed, come after 20 days. There are many offices are open for further advocates.
The,
Whatever it may be, it's a technical.
you can only consider, my lord, I have
I mean,
taken
you
that
are
down to
also, you are also appearing for the state in many cases and same grounds are there.
my lord, files in my.
Click here. The matter comes upon for consideration of the application, IA number so and so with a prayer to condone the delay of 155 days in filing the connected appeal. Learned counsel appearing for the respondent as opposed the application. Having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate. We are of the view that the delay a delay of 155 days in filing the connected appeal is satisfactorily explained, hence the same is liable to be condoned. As such, the IA number so and so is allowed, the delay of 155 days is condoned, registry is directed to register the connected appeal and list it for admission after 2 weeks.
Obliged.
We'll take care of it.
Such wasn't there.
My lord.
We'll
Next
take
time.
note of these arguments whenever you appear from that side.
I hope it is done in this appeal, my lord. Obliged.
For admission, item 29.
May it please your lordship. Lordship, this PIL, a notification, your lordship dated 7/3/2021, your lordship will find it at page 16. Annexure 1, your lordship,
3 months
is an
prohibition
attendance.
is there.
Yes.
your lordship.
3 months prohibition is there.
Even for a single day's prohibition is against constitution, your lordship. It
Okay.
is against the values of the Indian constitution, your lordship. That is why I'm before your lordship. It's an outright discriminatory, your lordship. It has a classification has been made on the basis of religious identity, your lordship.
Where is that? Which religion they have mentioned here?
Your lordship, that may be
In
seen,
the
your lordship.
notification, is there any mention
No
about any
mentioning
religion?
of any religion as specifically.
Yes, sir. Specifically, it has not been mentioned, your lordship. However, your lordship, if your lordship goes through with the notification, your lordship come to know that the transfer cannot be made between two religious person belonging to two religion, your lordship.
Only
That
for
is
3 months, sir. Only for 3 months.
Religious.
even for a single
some
day,
other
your lordship, it
religious
is.
Community. From some other religious community. Transfer
lord-
of some religious communities from some other religious.
Can it be a reasonable, your lordship, a classification, your lordship?
Let them find the response. They'll try to justify this.
So how can it be justified, your lordship?
How can they? at
Your
least
lordship,
Let them find the
Your
counter.
lordship,
then
may I
only
pray, your
they-
lordship, in the
then
meantime, your
only
lordship, the
judge whether they
notification,
have justified or not.
your lordship. In the
Without
meantime, the
any-
notification may be, your lordship, stayed, your lordship.
Okay.
It is provided, your lordship, if the district commissioner is of the view that the grant of such NOC is
Then he can
absolutely
very well-
necessary
Yeah.
for attending circumstances and will not lead to any breach.
So.
They can approach the inspector general.
You're having some urgency in the matter.
Lordship, urgency in the sense, your
Then
lordship.
why you have filed this writ petition after almost 2 months?
Your lordship, I approach your lordship through a
In fact,
representation,
on
your lordship, that
7/3,
was the
2024, this
Your lordship.
notification was
Your lordship.
issued. And you
Delay
have
is on
filed the
my
writ
part, your
petition on
lordship.
10th of May.
Your lordship, delay is there on my part, your lordship.
Then
However,
delay is
your
there,
lordship,
then
I
why you are
approached them,
insisting that- Why you are insisting now today that stay this
your
notification?
lordship. Your lordship, this kind of notification, if even if it holds its field, your, for a single day, your lordship, it is discriminatory
Let
against
them,
the citizens,
let
your
them
lordship.
find their counter.
Also, your lordship, details regarding petitioner number 2 has not been stated in paragraph number 4.
You take your objections, whatever in your
Yep,
counter.
they can, your
Yes.
lordship.
Only petition number
Only
1.
Counsel appearing for the, or you are appearing for all the respondents,
I'm for 1, for 2 and 3.
and who is appearing for the one?
Go to entry, who are they? Apply his name.
1 will be the government advocate.
All these are the government authorities.
I'm for the revenue department, your lordship. The notification has been issued by the revenue department. So I'm representing 2 and 3.
Why this?
I am for six.
PIL petition, the petitioner has questioned the validity of the notification dated 7/3/2024, whereby the Revenue and DM Registration Department of Government of Assam has prohibited whereby the state so and so Department of Government of Assam to curb the fraudulent transfers of land from some religious communities to some other religious communities has been prohibited for 3 months. In the notification, it is provided that if the district commissioner is of the view that the grant of such NOC is absolutely necessary for attending circumstances and will not lead to any breach of law and order, the same may be issued with the prior concurrence of the Inspector General of Registration, Assam. Just a minute.
This is issued by the principal secretary, your lordship. Signed by the principal.
वापस से बताना क्या लिखा है ऊपर से शेड्यूल से बताना no in starts Government of Assam has issued a direction to all the district to the authorities concerned not to issue NOC in case there is an attempt of fraudulent transfer of land by some religious community to some other religious communities for a period of 3 months. Okay. It is also provided that in case the district commissioner is of the view that the grant of NOC, such NOC is absolutely necessary for attending circumstances, the same may be issued with prior concurrence of the Inspector General of Registration, Assam. Full stop. Then it, council appearing for the Revenue and DM Registration Department, Ms. So-and-so, raise some time to file counter to the writ petition, time period for is granted. When?
After 4 weeks, sir.
3 weeks.
2 weeks, your lordship.
Obliged.
Oblige, your lordship.
Item 30,
Make the lordship. Lordship.
Lordship, in this case, I am appearing for respondent number 6. We have not received any copy of the appeal, Lordship.
You are for the private respondent.
Yes, Lordship, respondent number 6.
No, no, he said that your lordship copy has been pro. Yes, lordship, I will
No, no,
I will-
not even.
again. If
Copy has been pro.
Ultimately, the single judge, after taking into consideration the members were not present on the
Yes, sir.
selection committee for judging your suitability. What's wrong in that order?
After perusal of records, Lordship, this order was passed.
And this order is of 2019.
Lordship.
Now you are challenging this after 5 years.
No, this is some delay, lordship, delay was condoned.
Some-
Some delay was there.
5 years.
No, lordship, review petition was pending, your lordship.
484.
So there was some delay.
Ultimately,
I'll satisfy, lordship.
Review was also dismissed, Lordship.
Huh?
Review was also
Yeah,
dismissed,
that's
Lordship.
right, but after 5 years,
Yes.
now again you are questioning. What is this? What's the point in it? Really, you are serious? Your client is serious?
Lordship, I am serving as such a lordship as part the order of this court. your
How
lordship.
you managed to live these 5 years?
No, no,
Starving,
I'm
you are
con-
starving on the day your termination was there.
Even his appointment
How
was
you have
cancelled.
survived for this 5 years?
No, I'm continuing as lordship as part of the order to Lord and Singh will judge, your lordship. I'm continuing.
How can it,
Lordship, his lordship will find
in the result, the petitioner, the appointment of the ID is set aside?
23, your lordship. Have it- Page 23, have a look, your lordship.
Page 23.
Last, page 24, your lordship, last paragraph. However,
Over
18.
such exercise is completed. Respondent number 6.
6,
will
this is
continue to
appearance,
hold the
your
post of provisional basis.
lordship.
The aforesaid concluded within a period of 3 months from the date of receipt of certified copy of this order. So till date, they have not done any.
Selection,
Fresh exercise.
I have been selected, lordship, by this time, but appointment has not been made. Till I'm waiting, your
You have been selected again fresh.
again, your
No.
lordship.
In fresh,
Yes, fresh.
then what remains?
No, lordship, I have not been appointed as yet, your lordship.
Until and unless this, been go, if you have already been selected, then certainly they'll provide you appointment. Again, if you are selected in the fresh exercise, then what's the problem? Then why you are insisting on this appeal?
I'm waiting for the appointment, lordship. That's why I want to
So
revive
for
this
that
petition.
reason,
lordship.
that is a separate cause of action, you may file a separate writ petition. Pursuant to this direction of 2019, passed by the learned single judge, this fresh selection took place.
Lordship,
Then what remains in this petition?
Lordship, may I submit, Lordship? Pursuant to this order, Lordship, his selection appointment was cancelled, Lordship.
Yes.
The appellant's appointment was cancelled, Lordship, and fresh selection was held. In the fresh selection, Lordship, my respondent number 6, she was in the panel number, serial number 1, Lordship, and he was the last candidate.
Okay.
Yeah, but They lordship filed and repetition lordship challenging this selection process and it was stayed. And thereafter, lordship neither the
That fresh selection matter is challenged.
lordship, they have challenged lordship the subsequent selection process. They were not selected lordship, they were the last candidate.
There's some discrepancies in the allotment of marks was there. That's why lordship we came to
Sir,
this honorable court,
Well, we are not going into all this.
lordship. By
The
this time,
learned single judge, while setting aside your appointment, directed the concerned authorities to hold fresh selection. Now
Selection was there.
pursuant to that fresh selection already over,
over.
Yes,
then
lordship.
what remains in this petition?
And he was the last
No.
candidate. lordship.
Whatever it may be, we are not
Yes.
going into that. Now, what remains in this appeal?
Because lordship, I was been selected as third candidate. And I was in
Once
the pay-
once the direction of the learned single judge has already been carried out, how can this appeal can be continued? Yeah,
by this time, your lordship, that was
Nothing.
stayed, your lordship. See, Lord,
so you agitate your matter before the learned single judge where you have challenged the selection of the fresh selection. Agitate that matter.
that has already been over disposed of. That has been sent to the directorate.
Well, that
Right.
is then it's
This is the other.
much water has flown after this order, sir. How can you insist about this order? Okay,
Because your lordship,
that's all.
that is.
You understood that, sir? This writ appeal is filed by the appellant being agreed with the order dated 26/9/2019, whereby the writ petition filed on behalf of the respondent. You are respondent in this
Six,
petition.
lordship.
Respondent number 6 has been allowed and the appointment of the appellant on the post of principal has been appointment of the petitioner on the post of principal dated 27/6/2017 was set aside. The learned single judge has issued further direction to hold fresh selection process by considering all the candidates, including the appellant and the respondent number 6, in accordance with the rule. It is informed that pursuant to the direction given by the learned single judge, fresh selection has already conducted by the authorities concerned. Full stop. In such circumstances, when the fresh selection for appointment of the principal in the concerned school has already took place, we don't find any reason to continue with this writ appeal, hence this writ appeal is dismissed.
Pleasure. Item 21.
And the application.
Yes.
Malum. The learned single that we have challenged this order will learned single that only on 3 grounds.
Yes.
Number one, that learned single that has held that there was delay in approaching the court. Because this, as per the scheme, the petitioner appellant did not come to the
court in time or did not apply. Number two, number two, London Single has held that the judgment passed by the apex court, which I have referred, Srimati Syed Khadim Hussain is not applicable in this case. Number three, the London Single has admitted one thing, that the order of communication was of rejection of the application submitted by the appellant's mother was not communicated to us. Now, Lordship will kindly see this scheme. Lordship, first to Lordship see my repetition is, page 43. The repetition, my lord, I will read the paragraph 5 and 6. That the name of the mother of this applicant, Hasnara Begum, was recommended by the district level selection committee, but the state level committee rejected the proposal of the aforesaid mother of the petitioner by order dated 6 April 2018.
Following that.
Yes. My lord, para 6. That the name of the mother of this petitioner, Hasnara Begum, was recommended by the district level selection committee, but the state level committee rejected the proposal of the aforesaid mother of the petitioner by order dated 6 April 2018 on the ground that she was overaged. The learned single has held that she was overaged. I did not challenge it. How can I challenge it? Because on the date of application, she was 46 years. And they rejected the order, but they did not communicate to us. Paragraph 6 may be seen, my lord. It was not controverted by the respondents that they have communicated to us. Paragraph 6. That is respectively submitted that the state copy of the order dated 6 April 2018 was never communicated either to the mother of the petitioner or the petitioner. But coming to know from reliable sources, the petitioner along with his mother went to the office of the respondent on 11/2/19 and somehow collected the state copy of the order dated 6 April 2018 and immediately submitted an application to the authority for selection of appointment of the petitioner on compulsory ground, which was received by the authority on 11/2/19 itself. So we have annexed that copy. They have received it. And when they received this, they should have, as per the scheme, either consider or reject. But the DLC was sitting tight. That was our case. That the either DLC must accept or reject. That was not done, my lord. And this was by mistake or by some other ground. And this was not, it was ignored by the learned single judge. And I may be also wrong because in the repetition, paragraph 6, and the respondent's authority did not file any did not controvert it. And you will achieve your that Honorable Supreme Court held that once statements made in the repetitions are not controverted, this same should be accepted. Niha. Just a minute. Government of the epistle number. Nasim Banu case, Lordship. This case, my lord, the epistle held that unless it is controverted, statements made in the repetition should be accepted. Government did not file in a counter in the repetition, my lord. That is settled position of law. That is settled law. That is settled. Next, you Lordship will kindly see that regarding majority, when I have attained the majority, immediately have submitted, and there is no bar in the scheme that I cannot apply. This has been held in the another case by the Honorable Supreme Court in Khadija Hussain's case. I will pass it before Lordship. Lordship. Khadija Hussain. It is like this. Other topic? Yeah. This doesn't quite clear, madam. That a minor can apply after getting the majority. Lordship can see compassionate appointment. Person working as beyond infidelity died in harness in 1991, leaving behind widow and 5 minor children. Widow applied for compassionate appointment within time in 1993. Her application was rejected merely because it was not in the prescribed format. Appellant's son then applied for compassionate appointment in 1995, but his application was rejected in 2008. On the ground that he at the time of filing the application was added about 13 years. Hell, rejection of appellant's application was not justified, as at the time of rejection, appellant had attained the age of about 18 years of age. Authorities therefore must consider the application and give him appropriate appointment within 3 months. So, my lord, there in the it is a scheme for benevolent scheme for the persons who died on harness. The legislature has made this law to just enable the persons. Now, when the matter is pending before the government or before the honorable court, time has gone. So, another judgment I have, my lord, annexed in my repetition itself. Your lordship will kindly see that judgment passed by Honorable Justice Jacinta Molla Vijay Borua. Lordship will kindly see. Page number given. At page 83, my lord, of my rejection. The Honorable Single the held that when the delay take place, because that was the case where the petitioner's father died in 2009, and the repetition is allowed in 2017, because the matter was pending before the government. Matter was pending. When it was pending before the government, how the petitioner can, my lord, should be blamed? Your lordship, my Honorable Justice Nair has done enough cases in this regard. Because when there is a delay, and another judgment passed by Justice V.K. Sharma, my lord, has been referred in this case by Justice at page 83, lordship kindly see. I will read the relevant portion. Page 84 of my appeal. Page 84, paragraph, middle portion. The office memorandum of the government of Assam clearly provides that the application is to be made within a period of 1 year from the date of death of the concerned person, and even if it is made after a period of 1 year, also in a given circumstance, the delay can also be condoned. The above premises, the view expressed by the Superintendent of Police is contrary to the prevailing law, as well as law laid down by the this case by the court in Ushirudhan Das and Hajiran Nesa. Hajiran Nesa case, my lord, I could not collect the copy. It was passed by Honorable Justice V.K. Sharma, where the Honorable Justice held that when the case is pending before the authority or before the government, that delay cannot be contributed to be a negligence on the part of the agreed person. Yes. So, my lord, last para, it is directed that the respondent shall place the application of the petitioner for compassionate appointment before the next available DLC. So our also application, my lord, maybe either may be considered or may be rejected by the DLC. That is the prayer, lordship. Yes. That is the prayer. Let the DLC take a decision. Take them. They may accept or may reject. Take them. This writ appeal is filed by the. My lord, another 2 judgments are here. Lordship, passed by Honorable Justice Molla Borua. This is another case, singular case, lordship. No. It is better. Radesh not. It is only Radesh not. Our Honorable High Court held that that the policy is a benevolent policy. DLC has to pass. DLC has to pass an order. Yes. I will read the first in the top. Power of the High Court is to issue certain writs, seek to justify rejection. Yes. Attaining majority application for compassionate. Learned counsel for the petitioner, learned senior government advocate for respondent. Petitioner Rabindra Chandra Nath, who was working as an armed branch constable under Superintendent of Police, Kasar, died in harness motorcycle accident while he was on official duty time of his death. Petitioner was attaining majority, submitted an application for compassionate appointment held. Both in state of Madhya Pradesh reported wherein wherein has been provided that in respect of compensation appointment scheme, prevalent date of deceased employee is only consideration. Or interfering with the rejection of claim or the petitioner for compensation appointment by the GLC of Kasar district in its meeting. Application for petitioner stood rejected on the ground of late submission. Late submission in a circumstance where death had occurred, applicant was met time of death, petition was a minor. But after attaining after immediately attaining the majority, application for compensation appointment was made, so it was allowed. Under the government cannot say that a person, a son attaining the majority cannot apply. This scheme did not say, although it should be seen in a positive way, not in a negative way. Madam.
Yes. John,
Yes.
anything else? This writ appeal is filed by the appellant, being agreed with the order dated 6/12/2023, passed by the London single judge in WPC number 2930/2019, whereby the petition filed by the appellant has been dismissed. Full stop. The appellant has approached the writ court with the grievance that her application for compassionate appointment in lieu of death of his father, who was government employee, has been dismissed by the authorities concerned illegally. Full stop. The learned single judge has dismissed the writ petition mainly on the ground that the appellant has approached the authorities concerned seeking compassionate appointment in the year 2019, whereas his father expired. His father, a government servant, expired on 6/5/2018. The learned single judge was of the opinion that when the appellant and his mother survived immediate hardship, the decision of the authorities concerned of rejecting the application of the appellant for compassionate appointment, on whatsoever ground is not liable to be interfered with. Full stop. Para. The scheme of compassionate appointment is a departure from the general provision providing for appointment to a post of providing for appointment to any post after following the procedure for recruitment. Full stop. It is also to be noticed, it is also to be keep in mind that the scheme of compassionate appointment is not a source of recruitment, but it is a benevolent scheme floated by the government or the public sector undertaking, floated by the government to see that the deponents of the deceased are not deprived of means of livelihood. Full stop. Essentially, it enables the scheme of compassionate appointment enables the family of the deceased to get over the sudden financial crisis. Full stop. In the case in hand, the government servant, father of the appellant expired on 6/5/2019, and his application
and his mother's application and the application of the mother of the appellant seeking compassionate appointment was dismissed on 25/1/2019. Thereafter, the appellant has filed application seeking compassionate appointment in the year 2019, which will stop taking note of the fact that for all the intervening period, after the death of the father of the appellant, the petitioner, his mother and family members have survived the hardship. Without going into the merits of the case, we are not inclined to interfere in the impugned judgment passed by the learned single judge, hence this writ appeal is dismissed.
My lord. My lord.
Yeah,
My lord, that lordship, that DLC did not take any decision.
yeah, we'll take care of that.
My lord, let the DLC take the decision.
We'll take care of that. We'll take care of that. In the order, we'll take care of that, whatever. If there any factual correction, we'll make it. We are not inclined to since the orders have been passed. No. Yes,
Item 42.
No, in this case, we are agreed by the order, the judgment passed by the single judge, that is at page 348, my lord. If my lord may kindly peruse page 353, my lord.
yes, sir.
Paragraph 9 of page 353. Mr. So-and-so, learned counsel for the state respondent has brought the records and submits that there is no official report of the state government regarding the official loss sustained by the lessee. However, the district fishery development officer reports provides a calculation as to the basis for coming to a new rate payable by the respondent number 8 per annum for operating the fishery, which is at rupees 2,58,300 per annum. But my lord, there were numerous other reports which were not placed by the government council on that day, my lord, because we have annexed all the relevant official reports, which starts from page.
What is this jetty NGO judgment?
What has happened, my lord? 2014, the settlement was passed in my favor, in my appellant's favor.
Jetty NGO judgment on which the
That is there, my
single
lord.
judges place reliance.
The duty NGO judgment is a page, my lord. Page 206, my lord. Page starts from page 206, my lord, and the relevant portion is at page 211. Coming to the conclusion, paragraph 26, my lord, at 211. Coming to the question of relief that can be granted in this case, this court has noticed that the highest bidder quoting the price of rupees so and so is not a party to this proceedings. In the absence of the highest bidder, no writ of mandamus can be issued in favor of the petitioner. Thereupon, the NIT was also issued on 3/7/2014, that is more than 2 years back, and considerable amount of time had elapsed since then. Such being the position, while setting aside the settlement made in favor of respondent number 5, the matter is remanded back to the authorities to take a fresh decision on the question of granting permanent settlement of the fishery in the light of the observations made herein above. So and so stands allowed to the indicated.
You were respondent and file in that.
I was there, my lord, but what has happened, my lord, the writ petitioner and Jyoti NGO, they couldn't run the fishery. And it was, he became a defaulter, it was, the settlement was made in my favor, my lord. That is on 30th of November, 2000. At page 54, my lord, 30th of November, 2017, my lord. I was allowed to run from 2017. Initially, the settlement was made in my favor in the year 2014, my lord.
Just a minute, now hold on.
So this order was passed in 30th of November 2017, my lord. And that this order was not challenged by any other
Which
party.
order?
Page 54, my lord.
Which is
I was, page 54, my lord.
54.
The settlement order, page 54. Upon Jyoti NGO, upon not being able to run the fishery, I was allowed to operate the appellate.
Matter relating to settlement of Brahmaputra, so and so, so and so. Yeah, pursuant to the order of the so and so, Brahmaputra, the honorable court might order the writ petition settlement above fishery in favor of set aside the revenue so and so. After detailed delineation, all relevant particular settlement with the direction corresponding to take such decisions. Settlement of fishery observation. There are altogether 8 bidders. These bidders briefly stated that there is observation in the case from the report. The grounds of rejection of the tender of NGO, the contention of the submitted by. So what was the reason for settling this fishery in your favor?
In my, in 2014, I was awarded the settlement, but Jyoti NGO had filed a writ petition because of which I couldn't operate. Finally, in 2017, I was allowed to operate because Jyoti NGO couldn't run the fishery. From 2017 onwards,
Jyoti NGO, what was the direction in the Jyoti NGO?
Jyoti NGO, the direction, my lord, is 211, my lord.
To take a fresh.
To take a
decision of
fresh
the
decision.
Permanent settlement of the fishery.
And accordingly, my lord, on 30th of November, this order was passed. And the writ petitioner, who is the private respondent in this case, they had withdrawn their bid, my lord. If my lord may kindly peruse, they had withdrawn their security deposit. I was running the fishery till 2020. I had submitted an application in 2019 for extension of the period because of the fact that out of 40 kilometers, my lord, I was operating in only 11 kilometers, my lord.
Daily basis will be here. You were given on daily basis also.
No, my lord, this is a regular settlement, my lord.
Regular.
Whether pursuant to this JT NGO, any fresh bid was.
No fresh bid.
Why?
They took a decision, my lord, because as per the order passed.
Took a decision. How can they take this decision?
Because my lord may kindly peruse at page 54, my lord. Peruse the order dated so and so in Jyoti NGO case.
Yes.
2/8/2007. That is the order passed in Jyoti NGO case, my lord.
But that is the order passed in the JT NGO. Peruse the order and then they are done contrary to that order.
That order was, my lord, that for granting permanent settlement. It doesn't say that they have to go for fresh settlement, my lord. It says, my lord, paragraph 226, my lord, page 211 to go for permanent
Fresh
settlement.
decision on the grant of question of permanent settlement.
Permanent settlement, my lord.
Permanent settlement of the fishery. What do you mean by permanent settlement?
And thereafter, my lord,
Can't have.
out of 40 kilometers, I was operating in only 11 kilometers, my
What
lord.
do it mean? If the order, this order remains there, this JT NGO, the state government is not.
And
open for the government
they
to-
acted upon this order by passing this order, and this order has not been put to challenge by any of the parties, my lord. This 30th of November 2017 order, my lord. And my period will get over only November 2024. Just
Whatever it may be.
another 6
You
months
enjoyed
left,
a
my lord.
lot after this segment.
6
You
months
enjoyed a
left,
lot.
my lord.
Nothing. You, okay. This writ petition is filed by the appellant. Being agreed with the order dated 20th of February 2024, passed by the learned single judge in WPC number 2764/2022, whereby the writ petition filed on behalf of the respondent number.
I was respondent, my lord.
No. The writ petitioners are respondents.
They are respondent in this case, my lord. They are
Respondent numbers
8 and 9 here, my lord.
8 and 9.
In the writ appeal. There's a
writ
writ appeal.
appeal.
8 and 9.
Respondent number 8 and 9 has been allowed And the learned single judge has set aside the orders dated 10/9/2020, whereby the extension was granted to the appellant for running fishery in question, comma, and the order dated 6/2/2021 issued by the Joint Secretary, Government of Assam Fishery Department, by which the lease of the fishery has been extended for 3 years, comma, has been set aside. Full stop. The learned single judge, having gone through the material available on record and also going through the facts and circumstances of the case, has held that a coordinate bench of this court in Jetty NGO versus State of Assam, reported in 2017, SCC Online, Guwahati 643, has given a specific direction for taking a fresh decision on the question of granting permanent settlement of the fishery in question. However, the authorities concerned, without taking any fresh decision on the question of grant of permanent settlement of the fishery, concerned fishery, has illegally settled the fishery in favor of the appellant, by the order dated 10/9/2000, in favor of the appellant in the year 2000, in the favor of the appellant on 30th of November 2017, and has further illegally extended the said lease for a period of 3 years on 10/9/2020. The learned single judge has also observed that the further order dated 6/2/2021 issued by the Joint Secretary to the Government of Assam Fishery Department, whereby the lease of the fishery has been extended for 3 years in favor of the appellant, is also illegal. Having heard the learned counsel for the petitioner, appellant, and after going through the judgment passed by the learned single judge in JT NGO Supra, we are of the view that the learned single judge has not committed any illegality in observing that the directions given by the learned single judge in JT NGO Supra, comma, which has attained finality, comma, has not been complied with by the respondents while settling the fishery in question in favor of the appellant. Hence, we don't find any merit in this appeal. The same is therefore dismissed. Yeah, I is number so and so are disposed of.
Item 33.
Notice returnable also and so. You're referring on behalf of?
Yes, my lord, board, response number 1, 2, 4, 5, and 6.
All the respondents are represented.
Everyone has appeared, Manoj. In
Yes,
fact,
everyone.
there's only one private respondent, respondent number 10.
10. Note.
Here also entered appearance on the last occasion.
Last occasion is under.
Today, unfortunately, I don't find. In fact, the name is also shown in the cause list.
Respondent number 3 is my lord, made as party respondent by.
Ah,
name.
there's one.
Respondent number 3
Correspondent.
by name.
Is he there now?
On the last occasion, I'm instructed that Mr. D. Nath had undertaken to appear on behalf of this respondent also.
If it is really issue notice, the respondents are represented through the councils in the presence, whatever the presence may mark, 4 marks. Note the presence, don't show is appearing on behalf of the respondent, service is therefore complete. The council for the respondents prays for time to file counter to the appeal, if so advised. But list after 6 weeks. Who is appearing for on behalf of that department? They are not implemented, whatever it may be, the question is regarding whether they are, their case is to be considered simply because they have retired, it is to be ignored or what, that is to be seen. There is nothing.
Will serve.
They'll, at their own risk, if they are not implemented. Yes.
Will serve a copy.
Item 25.
Wait, please, your lordship. Well, the appellant before your lordships is an industrial unit, was manufacturing, my lord, packaged drinking water. Now,
London single judge has relied upon the earlier decision of the.
no, my lord,
this
the
court, sir.
Lanet single judge has relied upon a wrong rule, my unamended rule. That's why the judgment has been rendered. That what had happened, my lord, I'll just briefly indicate. There were 2 clarifications issued by Commissioner of Tax in exercise of his statutory power under section 105 of the VAT Act.
Yes.
Now, in the one that led to any packaged drinking water, there, my lord, the commissioner did not take note of the amended rules. But in Vivek Stonecrusher's case, where the commissioner of tax in exercise of statutory power, while issuing the clarification, my lord said, the eligibility would be notwithstanding whether it is manufactured or not. Because that, my lord, word manufacture was not there from 2006 onwards. Inadvertently, my lord, the learned single judge relied upon unamended clause 3.
Which is that?
Yes. If your lordship would kindly come to page number 431, my lord.
Internal page of the judgment, sir.
Or judgment, yes. Judgment, 481, my lord.
Internal page of the judgment.
1 second, my lord, 1 second. Yes, internal page, my lord, 12.
Yes, which you are.
Para 14.
Para 14, clause
Yes.
2 of the said.
Clause 2 of the said scheme of 2005 defines the eligibility. It was specifically mentioned that industrial unit which is or was in commercial production before commencement of 2003 Act and was already found eligible for exemption under the scheme of 97 as per eligibility criteria of the industrial policy of 97 or industrial policy of 2003 shall be treated as an eligible industrial unit. Now, this is important. Clause 3 of the scheme of 2005 stipulates the limit on tax remission for an eligible unit. As per subclause 1 of clause 3, where an eligible unit registered under the Act of 2003 manufactures any good, that this word manufacture is not there after amendment, my lord.
Amendment,
Yes.
was carried out in which year?
2006, my lord.
2006.
Yes. I'm handing over 2 copies, my lord. Can I read it further, my lord, before I bring your lordship's notice? Other than those declared in clause 2 as not eligible, 99% of the tax payable of such unit, according to its return in respect of such goods manufactured in such unit, shall be eligible for remission or continue to be eligible for remission until the amount of such tax payable exceeds the unable quantum of the monetary ceiling or extended unexpired period of eligibility, whichever is earlier. Then if your lordships will kindly come towards the last sentence of that para 14, my lord.
Yeah.
It is, however, very significant to mention that the benefits in terms of this scheme of 5 can only be availed if goods are manufactured by eligible unit within the state of Assam.
Yes.
Now, my lord, will kindly come to the amended one, my lord. In the principal scheme for the existing para 3, the following para shall be substituted. Where an eligible unit who is holder or will be holder in due course of certificate of authorization in Form 4A or Form 4C as per the terms of the Assam Industries Scheme 97 on the date of commencement of the Act and is registered under the Act shall be entitled for remission of 99% of the tax payable by him during return period after commencement of the Act until amount of such remission exceeds the unavailable quantum of monetary ceiling or extended or unexpired period of eligibility, whichever is earlier remaining available to him at the time of commencement of the Act. So, my lord, this word manufacture was not there.
Earlier, do you have that earlier rule?
My lord.
Earlier rule, do you have that? Earlier
Yes. That, in fact, that scheme is annexed, my lord.
31.
Yeah.
Page 431. My lord, in fact, we relied upon clause 2 and clause 4, but Lanet Singhal just referred to, my lord, clause 3, page 431. Definition of eligibility. An industrial unit which is or was in commercial production before commencement of the Act and was already found eligible for exemption under Assam Industries Sales Tax Concession Scheme 1997 as per the eligibility criteria of the Industrial Policy of Assam of 97 or Industrial Policy of 2003 as case may be, shall be treated as an eligible unit. Now, what Lanet Singhal just relied upon is, my lord, 3 towards the bottom. 3.1. Where an eligible unit registered under Assam Value-Added Tax Act manufactures any goods in Assam other than those declared above as not eligible, that means these are the, my lord, negative list. 90% of tax payable by such unit according to his turn in respect of sale, such manufactured good in such unit shall be eligible for remission or continue to be eligible for remission until the amount of such tax payable exceeds the unavailable quantum of monetary ceiling. Then if your lordship will kindly come to page, next page, my lord. Clause 4, 1B.
Yes.
Issue of certificate of entitlement by prescribed authority. On receipt of application, the prescribed authority, after satisfying himself that the application is correct and complete in all respect, shall issue a certificate of entitlement in Form 2 appended to this scheme in lieu of the certificate of authorization ordinarily within 30 days. Such certificate of entitlement shall be issued from a financial year only.
So this amendment was affected just after a year.
Yes, ma'am.
That is on, say, 22nd of May,
Yes.
2005.
And my lord will.
And on 11th of October 2006, this.
Yes, yes. And my lord, there was a clarification issued by the Commissioner of Tax. Let me refer to that where, my lord, this amended provision is referred. But in the any packaging case, it was not done.
455.
If your lordship will kindly come to 465.
You're a
I'm appealing to the industry.
Industrial department. Who is-
Actually, my lord, it is the finance department
Finance department,
because it is the eligibility certificate is still there.
Yes. You are appealing for the finance department?
Yeah.
Did you reply to this? Have you filed that reply or what?
Before the learned single judge, they filed. madam.
But what about this,
Oh, that,
unamended?
the first time it has come to them, my lord.
Lordship, before the learned single judge, this point was never raised
But if
and
the-
there was
if
no
the-
reply
if
from
the
our.
Rule itself was amended and it was ignored or whatever it may be, not pointed out to the learned single judge, then are you satisfy us that even after this substitution of the new rule also, the unit which is not indulged in manufacturing is not entitled to control?
Lordship, with regard to the amendment made to the scheme of 2005, Lordship, that I will like to clarify from the department, Lordship.
Issue notice.
My lord, can I just point out one thing, my lord? If your lordship will kindly come to page 465 for a moment, my lord.
Yeah.
This was the order we relied upon before the learned single judge. Because here, please come to page 466, my lord.
How the learned single judge is dealt with?
That's why I'm showing it, my lord. Please come to page 466.
Yeah.
Now, para 3 is quoted, my lord.
Yeah.
Where that word manufacturer is not there.
Yeah.
What is relevant is one should be a holder of an eligibility,
Then-
not made. Then kindly see, hence those units which were eligible under AGST Act and were issued certificate of authorization have to be allowed to enjoy tax exemption for remaining period,
How
even that activity does not amount to manufacture under a bank.
How the learned single judge is dealt with?
The learned single judge has not dealt with this, my lord.
This notification or whatever.
Yes, yes, yes. It was
clarification.
part of the pleading before the learned single judge. We relied heavily on this. In fact, my lord, in the written argument also, we have pointed out this.
Issue notice. Mr. If you are for the number one,
That's the answer.
Mr. Lordship,
you are appealing for this number one.
No person there.
one,
Lordship, I will be appealing for 1, 3, 4, 5, 6.
1, 3, 4, 5.
1, 3, 4, 5, 6.
Single judge's judgment is.
1, 3, 4, 5, 6,
No
7,
problem.
2. You are appearing for 2,
I'm appealing for 2, 6 and 7 years.
2, 6 and 7.
2, 6.
2, 7, 2, 7. and- Sorry.
So all the respondents
Yes,
are
sir.
represented.
Duly
Big
represented.
care. Issue notice. Mr. So-and-so,
Abhi to bhare mein-
mark the presence, Mr. Courtmaster. Mark the presence. Mr. So-and-so put in appearance on behalf of so-and-so, services therefore complete. Copy of the appeal, you are in receipt of the copy of the appeal.
We have received.
None consent of the respondent placed for granted. Time to file counter 2D. Counter on behalf of the respective respondents. Rate, time rate for the granted, so the list on
But we will stay before this.
when,
Lordship, 2 weeks, Lordship.
list after 4 weeks.
My lord, before the learned single judge interim order was there, my.
Till next date, no coursive action be taken against.
Fine.
Yes, the appeal answer.
Item 26.
Keep your-
Lordship, this is an appeal by the state of Assam, Lordship. Similar appeals have already been admitted by the Honorable Court, Lordship.
Learned counsel for the respondent. Appellant has submitted that. The identical, the appeals involving identical controversy has already been admitted by this court. Admit. Learned counsel. Mr. So-and-so is appearing on behalf of the respondents. The sole respondent and service is complete. Connect with writ appeal number 50/2024.
Obliged, Lordship.
Obliged.
Item 28.
May I please, your lordship. This appeal is directed lordship against the order dated 19/2/2024 lordship passed by the honorable single judge lordship, by which honorable single judge modified the interim order dated 9/10/2024.
So, single judge observed that simply academic in charge, this person was appointed as academic in charge, not a sole principal.
Yes,
There is a joint inspector of school is required to in charge principal.
Lordship, my,
Academic in charge or what?
lordship, my writ petition was also lordship, same lordship. In my writ petition, my prayer is that lordship, I may be allowed to hold the academic in charge. Because lordship, the respondent number 4 lordship, he is a contractual teacher lordship, and he is not at all lordship in the cadre lordship. So how he will lordship continue as an academic in charge lordship?
Seventy-two.
Yeah, it will be a matter before the learned single judge. We are not going to pass any order.
Yes, lordship, but lordship, what happened lordship? By modifying this interim order lordship, although the respondent number 4 lordship had not filed any affidavit in opposition in the main case lordship. And just filing a IL lordship, he modified the entire case lordship.
What's the wrong with that? We are not going to this thing, these.
Lordship, then a direction may be given.
Required to academic in charge. What do you mean by, what's the academic in charge in the this interest of the students, if they have appointed it, why we have, how this court can question about the wisdom of the authorities concerned? Sir?
Yes, lordship, because lordship,
Only academic in charge.
academic in charge lordship, although without any lordship, one grade 4 staff cannot be appointed as a academic in charge lordship, because he is not in the cadre lordship.
Sir, that is for those authorities, if they appoint any grade 4 in staff or any grade 2 staff or 1 staff, that is for them. Why to?
Because lordship, he is not at all in the cadre lordship. So anyway, lordship, let the writ petition may be disposed of within certain time limit lordship. Otherwise, lordship, entire.
Sir, whether we can, okay. After attempting to argue the matter for quite some time, the counsel for the appellant has submitted that he does not want to press this appeal. However, prayed that the learned single judge be directed to dispose of the writ petition number 5784 or 72. Which writ petition is there? There are 2 writ petitions.
No, lordship, 5784. Lordship.
2020.
5784 2020 2023 expeditious. Dismissed in view of the above, the writ petition is dismissed. This writ appeal is dismissed as not pressed with liberty to the appellant to approach the learned single judge for early hearing and disposal of the writ petition number 5784/2023. We expect that if any such prayer is made on behalf of the appellant, the same shall be considered in accordance with law.
Item 29.
Oh, yeah.
Lordship, similar set of appeals, Lordship.
Yeah, that's. Order, you were there, na, compassionate.
Yes, I understand there are several appeals
Like concept.
against the common judgment,
Appellant is submitted.
against the common judgment. Yes, Mr.
Similar appeals involving, involving identical issues has already
Yes.
been admitted
Against the common judgment.
by this court. Admit. Sole respondent is represented through counsel, hence no need to issue notice. List along with, connect with writ appeal number 50/2024.
Item 41.
All of the. Order passed by the Central Administrative Tribunal, my lord, setting aside the transfer order, my lord, that is under challenge, my lord. My lord, the transfer order of the respondent, my lord, he is a Group A officer. And my lord, the transfer was in the nature of interzonal transfer, my lord, not within the zone. From one railway, my lord, from the NF railway to the central railway, my lord. So, my lord, the foundation on which the learned Central Administrative Tribunal has decided the my lord, case, my lord, was on a wrong basis of facts, my lord. My lord will take page 31.
31.
Yes. If I may read, my lord, page 31, paragraph 8.
Yes.
We observe that in the instant case, there has been violation of the comprehensive transfer policy of the railways dated 31/8/2015, which is statutory in nature and which entirely reads as follows. Normally, minimum tenure on a particular post at a time will be of 2 years and maximum tenure will be 5 years. For sensitive post, maximum tenure will be 4 years. Minimum tenure will not be applicable for junior scale, senior scale officers of Group A. However, in administrative agencies, relaxation may be granted by the cadre controlling officer. My lord, to this, my lord, we have already stated in a written statement that this particular clause is not applicable.
Why?
It is only in case of, my lord, employees within the zone, my lord, within NF railway, my lord, this particular clause is applicable. That aspect, my lord, we have very categorically, my lord, replied in our written statement.
There is that 38, this 1st of August 2015, this transfer policy.
38, my lord, that is at page, my lord. 51.
51.
My lord, 208, my lord. Page 208.
208. Yes.
My lord, clause 7 is that particular clause, my lord, which
Just
says,
in supervision of the, comprehensive transfer. That's it. You are saying that it is in relation to the inter-zone transfers.
within zone, my
So
lord.
where is within zone, where is that? From where we read this?
My
That
lord,
these policy, this provision is only in relation to the inter-zone transfers.
no, this is the transfer, my lord, the transfer of the respondent, my lord, it was by the railway board, my lord. The power, my lord, if we see, my lord, will take page.
No.
Yeah.
It is what you are saying that this tribunal has wrongly relied on this clause.
Yes,
It is only in relation to the employees who are, it is only to be applicable in inter-zone transfers.
yes, my lord.
So where is that? From where we gather this?
My lord, in fact, my lord, for Group A officers, my lord, the transfer is
First of
by,
all, you just
Malad.
satisfy us that then only
Malad, I
whether
will place one,
not
Malad.
here.
provision is applicable only in relation to
Malad.
internal transfer, that's
Malad, I
all.
will place one notification, Malad, that will clarify, Malad.
He's a group A officer.
He is a group A officer, Malad. Malad will take
He's
page,
a group A officer.
group A officer.
So normally minimum tenure on a particular post at a time will be 2 years and maximum 5 years. For sensitive post, minimum tenure will not be applicable to the junior oblique senior scale officers of group A. You are group A officer. And the tribunal has set aside the transfer order only on this ground that minimum year there is.
And
minimum
also on the
tenure
grounds of malafidness, Malad. Also on the ground of malafidness, but the person against whom the allegation of malafidness was made, he is not a made a party to the proceedings. Malad, this is an order passed by the railway board, Malad, and the allegation of malafidness is, Malad, at the zonal level. Malad, he also made a representation which was considered. Malad, before that, Malad, I will take, Malad, to the notification which I have given. Malad, this is the instruction given by the railway board for implementing the Supreme Court judgment relating to posting and transfer. Malad will take page 4. Page 4, Malad, tenure in zonal railway.
Yeah.
Production units and workshop. Minimum tenure in any post up to SAG will be 2 years and maximum 4 years. Eleven, Malad, there is a notification, page 211, Malad, annexure 7. Malad, the Malad will see the grade, then within zone, and the power is given, Malad, to the member or the DG or the member concerned.
Yes.
So, Malad, the power to make the interzonal transfer is, Malad, with the railway board.
Inter-zonal transfer, CRB, DG or member concerned, DG or member concerned.
Yes.
And he was there in, on the post from where he was transferred from how much time?
6 months.
So 6 months, Malad.
6 months.
But the entire tenure in the region is, Malad, more than 9 years. In the northeast region, Malad, the NF railway, he was more than 9 years.
Now he has been transferred from this Guwahati to
NF railway to,
Southern
Malad,
Railway.
South Central Railway.
South Central Railway.
South Central Railway. Malad, he has also represented, Malad, before the authorities. That was also duly taken, Malad, note of. Malad, the transfer order is at page 96, Malad, the initial order which was put to challenge. That is at page 96. It is not only one of the officers, Malad, there were other 4 officers who were transferred. And the petition,
96, yes.
96, Malad, the petitioner's name is, the respondent's name is at serial number 2. Shri Kundan Kumar, JAG, IR, SME, Northeast Frontier Railway should be transferred to South Central Railway and posted in the cadre against an existing vacancy. Thereafter, Malad, at page 99, he made a representation.
Check, he is 149. Yeah.
Malad, thereafter at page,
The Director General so and so, Government of Kolkata Railway Board. Kundan Kumar Jag. Yeah.
thereafter, Malad, at page 99, he made a representation against this transfer order dated 5/9/23, which was again considered, Malad, by the railway board, page 100. The reasons were specified, Malad.
I may read my lord page 100.
NFR Northern Front Railway to
South Central Railway,
South
SCR, my lord. So far as the allegations of malafidness was concerned, my lord, that was also clarified. And very categorically, it is stated that there is nothing on record as submitted in the representation. Not the allegation.
some contempt was also there.
Interim order was made.
And they didn't follow the order initially.
Then they force के उसको or this one OA is pending.
No, no,
No, or this.
nothing is pending.
No, none of the grounds, my lord, we have stated in the WS were taken into consideration.
Yes, what do you?
Well, in fact, the tribunal did not consider that there are two other aspects. Malafide matter, we have specifically alleged that they had an intention of bringing one particular officer to my place. My lord,
In whole railways, one particular.
yes, and ultimately he was brought. And he was brought, and my allegation was that he is
He was brought from there.
from here itself, my lord, just in charge by as an in charge. And my allegation was that he will indulge in corrupt practice, and in fact, he did. My lord, I have all these papers. My lord, so far as
Crusader for that this person don't bring this person अगर कोई ईमानदार ले आते उसकी जगह you are okay with that.
My lord, my submissions, my lord, I have alleged in the OA or original application three things. One, the violation of this transfer guideline. Secondly, my lord, there is page, lordship may kindly have a look at that, another guideline at page 107.
So violation of the guideline, but which provision you are like?
My lord, page 107, lordship may kindly have a look at. Page 107, my lord.
Yeah.
This is the Government of India, Ministry of Railways. My learned is not showing this. Ministry of Railways, Railway Board, and this is of 7/7/2014.
Yeah.
Implementation of subject matter, implementation of Supreme Court judgment dated 8/10/2013 in WPC number so and so, posting transfer in railways, corrigendum regarding board's letter of event number dated so and so. Please refer to para 2(1) and 2(2) of board's letter referred to above and read the same as under. For officers of the level of junior administrative grade and selection grade in the zonal railways and production units, construction organizations, RDSO, etc., and workshops, then thereafter the paragraph competent authority. The competent authority to accept the recommendations of the above placement committee will be general manager, head of the organizations. Now thereafter, my lord, lordship may kindly turn to the next page. There should be a committee to be constituted. I'm straight to reading.
Yeah.
Well, para one, this Honorable Supreme Court in judgment dated so and so in writ petition number so and so internally directed that there should be a committee to be constituted at appropriate levels to decide postings and transfers of all group A, B, and C officials, even if within the same zone. The postings transfers to be regulated by the transparent policies with assured minimum tenure. Policy provision may therefore be framed. Board has therefore decided that there should be a placement committee to recommend transfer postings of all railway servants as per Honorable Supreme Court decision. Following shall be the placement committee. So the transfer has to be recommended first by the placement committee, and then the transfer can take place. In this case, my lord, I have specifically made allegations in the original application that it was not rooted, no recommendation was of the placement committee. This was not denied by them. And my lord, I'll show a judgment. Your lordship is aware of that MP High Court additional district judge's judgment, where my lord, on this on Supreme Court has said, even if the transfer policy has been the transfer policy doesn't give any enforceable right, but if it involves arbitrary exercise of power, the Honorable Supreme Court said there.
So ultimately, you are here from how many years? What do you mean by arbitrary power? This is not, that doesn't mean that you will remain here for
Well,
in
well, here-
these many reasons, sir.
My lord, I am here for 6
Ultimately,
months
it's a
only.
transferable post.
My lord, I am
When you
here.
join this post, you are aware that you are supposed to be transferred.
My lord, yes, man. I am
And
here
8
only.
years now, if 8 years you are in this very much reason. then
My
what
lord,
is
I
the-
was in Dibrugarh. From there, I was brought here.
So Dibrugarh is, I think so it's far, Jaisalmer type
My
place.
lord, I'm not on that, my lord. I said, my lord, there has been.
In the very zone, you are in the very, this zone.
I mean, yes, in this zone. Transfer, my lord, this placement committee doesn't say that only in the
Okay.
event,
Will pass an order
my lord.
that you give your place of choice out of this zone. Will direct the railway to transfer to at the, in that zone.
My lord,
If you are not with the central railway, if you are not satisfied, you give your choice. Then ask them.
my lord, I am before your lordship.
You just,
My
you
lord,
are,
my humble submission before your lordship will be the order passed by the tribunal doesn't suffer from any infirmity.
that we'll see.
My lord.
That we'll see that they here. But so far as regarding this order is concerned, transfer order, you have to comply with that.
My lord,
Transfer matters.
my lord, specific allegations of malafide in the original application was not denied by them, my lord.
The person was not included as.
Only 6 months I was here.
Okay, that's why only, sir. 6 months here, not in northeast region, sir.
It is the interzone.
No, my lord, the transfer policy doesn't say that I cannot be there in a
Sir,
region.
we are giving you an offer.
My lord.
You give your.
Well, that I have to take instruction, man. I'll take instruction.
Yeah, after lunch, Leila. At 2.
Or can it be taken up on Monday, my next? Just
At 2. अभी एक बार बताइए.
Item 42.
OMR should take to bond. Making OMR evaluation of the conflict. ये 2 पॉइंट के लिए हमने कितना है वो अगर
Yes. Adjourn.
Oh,
The name of the advocate is not shown. In 32,
B Chakraborty.
the registry is directed to reflect the name of the counsel for the writ petitioner in the cause list and thereafter to list this matter.
Item 43.
My lord, 3 weeks time may be granted for filing reply.
Lordship, today is the first date only.
Oh, we will not grant the time.
It's against the, because I have prayed for stay also, Lordship.
Why stay?
My
Leave
lord,
encashment is entitlement is leave encashment is.
Yes, Lordship, he
entitlement.
was dismissed
My lord,
from service, Lordship.
actually, my lord, they have not yet incremented the order and we have not filed any contempt. So, my lord, stay may be granted.
This is against the order.
The order of punishment,
This dismissal from service without any,
dismissal order, where is the dismissal order?
Lordship, A1 page 41.
Even not done that he had only paid for. These.
41
Lordship, starts from page 41.
and concluding for
Lordship.
dismissible of service without compassionate allowance and pension and gratuity board.
Take to the effect of dismissal available on the legal petition. So, what if makes it that critical in return from the ceases from the place of the dismissal. कैश बोल दिया जनरल भी चला गया नहीं 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 वो इसमें गया पेज 108 is to be noted that by rule by 03 is related with it that the need can be paid. The lead can be paid. And the whole file has. That was on such and so. Basically. I already made plans to the American to make payment interpretation. 504 considerably. Is 550 on record?
Lordship, I have. The last page.
Maybe they is this is the we do the four man. Can you to repair the people? To the effective. Yes, relation. Relation. all by payment of fail. That could be. Feedback. I'm thinking of 5048.
503, right?
50.
504 and 550 is the relevant provision, but Honorable Tribunal said that these are not relevant.
Need beyond the period. No leave shall be. This leave for the. That is. I prepare. As all railway servants planning on supervision on or after. Attached to. In respect of the period. Until at the. So, predicting the new person book letter. This is your experience with it. These things are very good.
The Traves time may be granted for reply.
Stay this order will.
Well, actually for stay, they have not yet implemented the order.
That's why only we are staying there, otherwise you will file contempt for that.
Yes.
Notice, learning concept of the Land Council for the petitioner has submitted that the Central Administrative Tribunal, Learned Central Administrative Tribunal, Guwahati bench has erred in directing the petitioners to encash to grant the benefit of leave encashment to the respondents whose services have been dismissed. It is pointed out that as per rule,
Yeah, sir, Indian Railway Establishment Code.
as per
I asked.
clause 550 of Indian Railway Establishment Code, the 550,
50.
504, 504. Any claim to leave to the credit of a railway servant who is dismissed or removed from railway services ceases from the date of such dismissal. Full stop. Issue notice of stay, issue notice, London Council appearing for the sole respondent accept notice on behalf of the state. Hence, no need to issue formal notice. She, so and so prays some time to file counter to the writ petition. Time paid for is granted. In the meantime, effect and operation of the order impugned passed by the CAT shall remain state.
Much obliged.
इसमें will issue the notices, you are
Hello.
appearing for
1, 2, and 3.
1, 2, and 3.
Right.
What about the other respondents? I'll be appearing for my 4.
And 5 is also there, man. Give me a sec.
I'll be appearing for 4.
Union of India.
Union of India.
Union of India. 5 is CGC. Yes.
Mr. David. David.
Issue notice. Yeah, you will be right, this PIL petition. The petitioner has raised a concern that the respondent authorities are not taking effective steps to preserve the ancient literature in the Assami language.
Literature, Assamese, protection of Assamese language.
Not taking
Protection of Assamese language in terms of the Act
Taking-
96.
measures for protecting the Assami language. Full stop. Issue notice of the writ petition, Mr. So and so are appearing on behalf of all the respondent number so and so services therefore complete. The respective respondents may file their response by filing counter affidavit within a period of 6 weeks.
Expect of which may be directed to the. Will furnish money. May only pray for debt, man.
You are not on talking terms.
Yes,
You are not
yeah.
in talking terms.
Sometimes,
No,
my lord, absolutely. Why will also?
Sometimes, my
Lord,
lord,
Sometimes you are not talking terms with the others. No?
take my lord, man, advantage for not.
Ask if we refuse to do so, then only we'll pass
That's
the
the
order.
problem, my
Might
lord.
be
Sometimes we
simple.
face, that is why, my lord.
It's implied, man. Lordship, may only pray for debt, sir, if possible, man.
6 weeks के बाद में फिर
Oblige.
Item 41.
He was informed about the what this honorable court feels about his case. And he feels that he will still, he still feels that he will get justice from this honorable court.
He is.
And he feels that he will get justice from this honorable court. 3 documents, and I'll just point out to your lordship. Lordship will consider.
Yes, we are. for
Just
this
5
only,
minutes, my lord.
but,
Lordship will give me
maybe,
just,
other side also.
my lordship will give me just 5 minutes. I'll not take much time, just 5.
Fine.
Page 104, lordship may kindly have a look at once again, my that transfer policy. And the very first paragraph says, page 104, Roman 1 under serial number 1, my lord. Ordinarily, a Group A officer will not be transferred out of his allotted zone until selection grade. Lordship has got my lord. Page 104. After 1, Roman 1, first Roman 1, my lord. Ordinarily, a Group A officer will not be transferred out of his allotted zone until selection grade.
Oh.
And I have not reached the selection grade. So that way, ordinarily, I should not be transferred. Well, the second document, which I have already shown to your lordship at page 107 and 108, there is a clear-cut policy pursuant to a direction of the Honorable Supreme Court that every transfer will be placed before the placement committee. It was admittedly not done. And thirdly, my lord, our client desires that I should point out to your lordship at page 99, what is the reason for the transfer? Just, I'll read one paragraph from page 99, my lord. Page 99. This is what he wants to say against his transfer order in the representation that is submitted, man. Page 99, man. I'll not take much time of your lot.
Yeah.
Page 99. With due respect and humble submission, I would like to state that I was transferred from Mechanical Workshop Dibrugarh to Coach Maintenance Depot Guwahati in the month of February 2023 and posted as so-and-so, so-and-so. I have continuously monitored and executed the contractual work without compromising the legality, quality of service by taking number of initiatives that resulted into
Sorry,
bringing down the...
just- It's- Yeah.
Page 99, I'm sorry. With due respect and humble submission, I would like to state that I was transferred from Mechanical Workshop Dibrugarh to Coach Maintenance Depot Guwahati in the month of February 2023 and posted as so-and-so. Being so-and-so, I have continuously monitored and executed the contractual work without compromising the quality of service by taking number of initiatives that resulted into bringing down the number of passenger complaints. Sir, in addition with that, I have motivated and encouraged my subordinates to work rigorously during duty hours despite large number of complaints from trade union. Sir, someone tried to create conspiracy with bad intention against me to tarnish my image by propagating false information to social media, news media, as well as administration. Sir, one of the instance, I had denied to commission the boot laundry despite repeated requests by the farm, as the farm was not supplied the basic parts of main machine, which allegedly resulted into circulation of false information and alleged allegation against me via social media, news media. I had immediately informed the same to so-and-so CRPO and requested to conduct inquiry against the incident and punish the culprit who had tried to tarnish the image of Indian Railway. Sir, as a person of ordinary prudence, I have taken all the decisions for the benefit of railway, but within 6 months, I am again being transferred from NFR to SCR, since because of I did my work with full honesty, ethics, and dignity for the benefit of Indian Railway, I feel humiliating, demoralized. This resulted into mental trauma for my family members and will badly affect the mental condition of my children who recently got admission in their respective schools. Therefore, I request you to kindly review my transfer order.
This is nothing but self-praising yourself.
Madam, what
That I have done so and so. Everybody is doing for that. Every employee is doing that. What's the extraordinary circumstances and you get mentioned that your children recently got admission
No,
in their respective school in February 2023. This order is of 27/9/2023. How it is recently?
No, I'm not on that. What I'm saying, he has tried to project that I am an honest officer, and particularly.
Sir, who is doubting that?
I'm not saying. What I'm saying is,
So you mean to say that if a person who think himself as a who claiming himself as an honest officer can't be transferred?
I'm not saying that. What I'm saying is, my lord, the purpose of transferring me out is that I have not, my lord, assisted them or helped them in indulging in corrupt practice. This boot laundry, my lord,
That is here and neither here nor there.
my lord, there is no,
Persons have
my lord, there is,
pressurized me to do wrong things.
my
and I
lord,
have
there
not
is
done
no
things.
other,
That is your duty.
my lord, there is no other administrative agency to transfer me out. That is my,
So this is not that.
and my lord,
Page 100, my lord. The representation was considered next page.
And now now in the next phase, they have praised you like anything.
my lord, their purpose is I should go out.
They have in fact acknowledged your best
lord,
work or
my lord, they
honesty. They have acknowledged your
my lord, this
honesty.
acknowledgement is unheard of. My lord, you are harassing me on,
They have acknowledged, yes, you are a very good
on the-
officer.
on one
And
hand,
for
you
your
are,
career progression, now they are
I have seen that,
sending
man.
you.
My lord, on the one hand,
You must feel obliged by them.
my lord, on the one hand, they are punishing me by transferring me out, and on the other, they are praising me.
Transfer is not a punishment.
True, my lord,
It is a settled
I know.
principle of law.
My lord,
That is the incidence of service.
my lord, my humble submission before lordship is, my lord, our client wants that let there be an order on merit, my lord, because the transfer order does not apply to him, my lord.
An order.
My lord, my lordship,
Only
104, my lord, clearly says ordinarily a group A officer will not be transferred unless he
that
gets
is what
selected.
you mean by ordinarily. You are interpreting it like this. Ordinarily means it should not be transferred
Yes.
in any circumstance.
No, that I'm not saying ordinarily not, but my lord, if there is any special,
Suppose a person is suffering from some serious ailment or something else, then certainly ordinarily shall not be transferred.
my lord,
Otherwise.
my submission will be, my lord, ordinarily, this sentence means that if there is a special circumstance for which I should be transferred, there is no special circumstance. my lord.
So where is the question of special circumstances? That only a person, then they should have been framed like this, that the group A officer can only be transferred in a special circumstance.
I'm not saying what my
You are
submission.
trying to interpret it like.
No, my lord, I'm trying to interpret in such a way that ordinarily I should not be transferred till I attain the stage of selection grade. Now, if they still want to transfer, they have to show, my lord, that it's not an ordinary case. We have to transfer because of this reason. Nothing is there, my lord.
They've shown that they make it the special case that for your career progression, since you are a very honest officer and not going to any pressure.
My lord,
Therefore,
if your lordship permits me, I'll take your lordship to the several paragraphs of the original application where I've specifically given details of the reasons for which I am transferred. And they want,
is always there.
and for the, I've been transferred for the purpose of accommodating another person.
So the cat is impressed by your, whatever you have said in your OA, that he is malafidely transferred or what?
Malafide aspect was not dealt with in so many.
Then.
But yeah, I said, Mara, it's a case of not malice in fact, it's a case of malice in law. They have transferred me for a reason which is not there, which is not germane to a normal case of transfer, my lord.
Normal case, now you are trying to interpret that only a person can be transferred or a group of officers can be transferred in
my lord,
special circumstances, otherwise he can't be transferred.
And my lord, they have no answer to my argument at page 107, page on 107 and 108, that it should have been placed before the placement committee.
For that,
What is the,
for that I have given instruction, my lord.
The Supreme Court says you
Lord,
do something,
there is
they
a
do it, then they
clarification
have
by the
not
railway
follow
board.
it, my lord.
On that aspect, my lord.
Where is that?
Yes.
This dated?
Lord, next page, my lord. Second. This is the comments which we have received from the railway board.
You're posted here in this northeast region since when?
My lord, since 2014, my lord.
Exact date?
To page 2. 0. No, page 166, my lord.
One?
166, my lord, detailed chart is there, my lord. Paragraph 8. my lord. 15/6/2014, my lord, at Lamding, then Guwahati, my lord, Dibrugarh, goes on, my lord. Paragraph 8.
Indian Railways and-
My lord will kindly permit me to show, my lord. This is the Supreme Court judgment based on which this committee was. And I've given a copy. Para 34, my lord, state your lordship may kindly go to page 753. Para 34. We. Lordship, Para 34. We therefore direct the center, state governments and union territories to constitute such boards with high-ranking serving officers who are specialists in their respective fields within a period of 3 months, if not already constituted, till Parliament brings in a proper legislation in setting up CS.
So where is that, this, for the purpose of interjournal transfers also, they are required to constitute a committee for that. purpose?
That is not clearly said, but then
So
pursuant
once
to
the
this.
board is saying
My lord.
that they have not constituted any committee for recommending interjournal transfers, and those transfers are done on the recommendation of the cattle controlling authority that is concerned railway board member. What's wrong in that? sir?
My lord, this document they have not first time. they have produced.
This is the clarification they have issued for the purpose of filing reply to this or whatever for assisting the court.
We were not.
This was produced during the course of the hearing. Can. Written statement.
This writ petition is filed by the petitioners being agreed with the order dated. The impugned order is dated
My lord, impugned order is dated. There are 3 orders. My lord, initial order is 5/9/2023.
22/3/2024, page 22, my lord.
23,
22/3,
22/3,
2024.
2024.
That is the order passed by the
Central
tribunal.
Administrative
Yeah.
Tribunal, Guwahati bench, whereby the transfer of the respondent, who is working as grade A officer,
Yes, my lord.
Yes,
as grade A officer,
Group A, man.
Group A officer in the North, what is the
NF
name
Railway.
of that?
No, Northeast Frontier Rail. NF Rail.
NF Railways has been, NF Railways, Central Railways has been set aside. Full stop. Learned Counsel for the petitioner has submitted that the Learned Tribunal has taken into consideration the clause 3. Where is that?
page 208, my lord.
208.
Clause 7, my lord, Roman 7.
Page.
Page 2.
50. Very.
Last. The last of the. brief. End of. 111. Yes. That's 31.
Clause 3 of the transfer policy dated 31st, clause not 3, clause 7 of Roman in para Roman number of the transfer policy of the railway dated 31st of August 2015, which provides that tenure of a particular post at a time will be of 2 years and maximum tenure will be 5 years. It is contended that in the very same clause, it is clearly mentioned that the minimum tenure will not be applicable for the junior scale and senior scale officers of Group A. Learned Council has further submitted that even if it is assumed that the clause 7 of the transfer policy is applicable, then also it speaks about the zonal transfers only, transfer within the zone itself and not interzonal transfers. It is submitted that the respondent is posted in North Front region since 2014 and at the time of his transfer by the order dated 15/9/2023, he has completed around 8 years of service in the Northeast region. And therefore, the railway authorities have transferred the respondent looking to the administrative exigencies. It is further submitted that it is further submitted that though the respondent in his OA has leveled allegation of malafide against a particular officer, but that officer has not been implicated as party respondent in the OA, and the learned cat, without considering the above aspect, has illegally set aside the transfer order. Full stop. Learned Counsel for the respondent has argued that as per the transfer policy of the railway, a Group A officer is ordinarily not to be transferred out of the zone where he is posted. It is submitted that the respondent railway has failed to indicate any specific reasons for transfer of the respondent out of the respondent from Northeast region to NF railways to Central railways. Full stop. Learned Counsel has also pointed out that for the purpose of transfer of a Group A employee, the recommendation of the
Placement committee.
placement committee.
Right.
Placement committee is necessary, and in the present case, no such recommendation is there, and despite that, the respondent has been transferred. Full stop. In reply to the same, learned concept of the petitioner has submitted that as a matter of fact, there is no committee to recommend interjournal transfer of Group A officers, and the interjournal transfers are done on the recommendation of the cadre controlling authority, that is the concerned railway board member. And in the case of the respondent, the cadre controlling authority, that is concerned railway member, has recommended the transfer of the respondent. Full stop. Having heard the learned concept of the parties, we are of the view that matter requires consideration, hence admit no need to issue notice as parties are already represented. In the meantime, effect and operation of the order, impugn order dated so and so passed by the learned cat of Guwahati bench shall remain state. South Central,
Madam, my salary-
South Central.
My salary has not been paid even after the order passed by the CAT.
We made it clear that the respondent authority shall clear the arrears of dues of salary
My lord,
to the respondent.
my lord, here they have, he's already, my lord, there is a sparing order. My lord, he has already been transferred, my lord, he has already been, page 98, my lord, will see, there is a sparing order. He has been, he is no more in NF Railway now.
What we have. Up to May 2024 by 31st of May 2024. After clear kar de whatever.
No.
Tell me he'll join there. You give him the salary. Don't punish him twice. But you have transferred and now we are not paying the salary. That is not proper.
He is not in NF Railway, my lord, as on date,
Whatever it may be, from where railway is the same,
my lord.
pay the salary.
Item 45.
May I please, your lordship? Lordship, the respondent of 7 is the principal of the school. He was suspended by the departmental authority, that is the director, on 9th of February. Lordship, kindly have a look at page, Lordship, the very first annexure, page 22. Here, Lordship, the last page, the last paragraph. In the interest of public service and until further order, the inspector of the school so and so is hereby temporarily allowed to act as in-charge principal of Pazitullah so and so school. But Lordship, in fact, the in-charge inspector of the school is not informed. And the principal continued to function as principal of the school.
So, what he is doing there?
He, Lordship, withdrew money from the bank account and misappropriate all the midday meal, etc.
To file a criminal complaint.
Lordship, the public made complaint before.
I mean, if you are aggrieved, file a complaint. It's the
Lordship,
if he is
complaint.
misappropriating the fund, he is committing a cognizable offense.
Lordship,
Then file a complaint with the police. How this PIL is maintainable? You just tell me it's a, how this petition can be termed as a public interest petition? This is purely individual.
no,
You are against one person only. How many persons are involved in corruption in the state of Assam? Are you raising concern about all those persons?
no, Lordship, not,
Such kind of PILs, particularly where the personal interests are at large.
Lordship,
They are not going.
I'm not on the misappropriation of the fund. The fact is that even after suspension of the principal,
Sir, how you are concerned with that? That is for the authorities
one of-
concerned.
Lordship, definitely,
You are a vigilant citizen.
Lordship.
So how many persons in the state of Assam or you are raising concern are indulged in these activities? And despite their suspension, they are doing work or whatever it may be. How many petitions you have filed till date? How many petitions you have filed till date? I mean to say that this particular your petitioner, this person is so vigilant, then he should have raised about all other employees also. Why singling out this person only? Shinchi, your grievance may be genuine, sir. We are not doubting that. But at least for the purpose of PIL, then if such type of PIL are to be entertained, then we'll be flooded with all these PILs. Everybody will come and make whatever kind of genuine or ingenuine allegations against any employee or any person to say. If you are agree, you may file your complaint with the police. Police is bound to register the FIR in respect of every cognizable offense.
Lordship, complaint is filed before the departmental authority as well as the vigilance.
Whatever it may be,
and
we are
because of Lordship.
not going to entertain this petition, sir. If you want, you can withdraw it and avail appropriate remedy, whatever you want.
I may be allowed.
Wants to, after attempting to argue matter for quite some time, and the concept of the petitioner on instructions has submitted that he wants to withdraw this. Writ petition, however, seeks liberty for the petitioner to initiate appropriate proceedings against the irregularities, misdeed committed by the private respondent.
Item 46.
Against the alleged irregularities and misdeeds.
Respondent number 7.
Respondent number 7. Was it a private respondent?
Go ahead.
That's a no. Respondent number 7. Yeah.
Kindly pass over a matter for time being.
My lord, in a second up, I have some personal difficulty, my lord. In that case, my lord, any date may be fixed on next week, my lord.
Wednesday, next Wednesday.
Last occasion, Mr. Chaudhary got
Yes.
time to address some on some point. Otherwise, we are not inclined to entertain even this petition.
Let's in another court, Lordship.
Nothing in this.
He has problem, Lordship, second half.
But ultimately, this, whatever your discontinuation is not stigmatic. People simply said we are not going to engage you after expiry of the contractual period, that's all.
Pass over a matter for time being, Lordship.
My lord, some personal difficulty is there, my lord.
Quickly. You open the other table, we put it on.
Tuesday.
Wednesday, Lordship. Tuesday, senior.
Okay, Wednesday, ultimately the result would be the same. Whatever, you choose your auspicious day for that. Yes.
Oblige.
Item 47.
May please, your Lordship. The matter relates to the whether the applicants are entitled to old pension scheme, Lordship. Out of
So
the,
similar appeals have already been
yes, Lordship, item number 22, today's list, Lordship.
22, 23 is not the similar appeal.
Out of same judgment, Lordship.
Out of the
Same
same,
order, Lordship, impugned order, Lordship.
another set of employees,
Oh, they have,
Yes, sir.
that delay was conducted.
delay was. That delay was there. Should notice returnable funds. Yes.
Item 48.
So, yeah, it's a- What I'm doing. Let me
Ultimately, it's the concurrent finding of fact.
Two
How
substance,
far we are going to interfere in all this?
pardon, Lordship.
How far this appellate court can interfere in this? Labor court has affirmed that, and the learned single judge with a minor change has affirmed those procedure, the finding of facts.
Certain the basic question which was raised before the learned single judge,
Yes,
that the fairness of the domestic inquiry was not proved at the
that the
principle.
learned single judge has opined that
No,
there is no integrity in
That
that.
is why my submission on that point, that certain components which constitute the principle of natural justice while conducting the domestic inquiry has been overlooked while deciding the case. And second most important issue is that, Lordship, that the workmen who were terminated, they were acquitted in the criminal case.
That is altogether the scope of this departmental inquiry, and this criminal trial is altogether different, and I don't think so. We are required to apprise you about that. You are aware of those, all those settled principle of law.
That the standard proof in the criminal case is beyond reasonable doubt, and in departmental proceeding, it is the preponderance probabilities. But my submission is that Supreme Court says that
Yeah,
if the charges are same, if the evidence is same, and if the witnesses are also identical in nature, then the matter acquire different dimension.
no. Can't be.
I will place on citation, Lordship.
Nothing in admit.
Lordship.
Now happy with this order all. Yes. Admit issue notice, that's all returnable 8 weeks.
Item 49.
May I please, your Lordship? Lordship, the interim order is at page 17Q1, Lordship.
ये भी नहीं बोलना कि
Issue notice
Lordship.
returnable 2 weeks registered AD.
You have not filed an IF for interim.
No, Lordship. All right.
Item 50.
May I please, your Lordship? Lordship, the Angus Council is out of station. Kindly pass over the matter for the day.
बोल दिया है कि 12 है तो contradictory orders तो 11 यहाँ पे बोलते हैं कि मुझे that's unfortunate.
Yes.
Lordship, the Angus Council is out of station. Kindly pass over the matter for the day.
Otherwise, there is nothing in the matter.
Thursday. The only thing is that the learned single judge has decided the writ petition in the absence of the council. This is what they are. Yes.
Item 51.
Lordship, this appeal has already been admitted, Lordship. One of those compassionate
Concept
appointments.
for the appellant has submitted that identical appeals involving, writ appeals involving identical.
Already admitted.
So it is already admitted.
Lordship, on 10/4/2024.
The matter is already admitted list for hearing
Lordship,
along with the connected appeals.
obliged.
Okay.
Item 52.
In this case, we prefer the appeal. Respondent on after receipt of the notice, they challenge the maintainability of the appeal on the ground that the appeal lies before the Supreme Court. Lordship, I require some time to respond to their affidavit. Because as per our,
Okay, Mr. Kyle, learned counsel for the applicant, raise some time to counter the preliminary objection raised on behalf of the respondent based on terms.
For hearing, item 53.
I appear for the appellant, madam. I and my other colleagues, madam, we have retired from the matter. We have also put the client to notice, madam. So my lords may kindly adjourn the matter, perhaps on the next date, he may engage some.
You
other-
raised the post, inform the.
Yes, we have notified the the client, madam.
Okay. Mr. So-and-so, appearing on behalf of the appellant has submitted that they have already withdrawn their power and has also informed the appellant. Full stop. Let this, in the interest of justice, let me, this matter be adjourned, this matter is adjourned for 4 weeks. So that the appellant may engage a new concept.
My lord, I have a small prayer, my lord. Let the registry be directed to reflect the name of standing council higher division.
After reflecting the name of so and so, so that the appellant can.
And our names will be kindly deleted, madam, from the.
Let other advocate may come. Otherwise, every time you come and inform us that you have already informed.
My lords, deeply.
Item 55.
may I please, in Lordship, Lordship, this writ petition is directed against an order of the learned CAT dated 15/6/2016, directing payment of HRA to the applicant therein. And the order, Lordship, will find at page 9.
Yeah.
If your Lordship will peruse from paragraph 4, that is page 11.
Yes.
I'm just reading out slowly, Lordship. This OA applicant makes a prayer for setting aside impugned order dated 21/9/12, as well as order dated 17/3/15, whereby applicant's claim for grant of house rent allowance was rejected without appreciating the relevant general rules and orders on HRA issued by the Government of India from time to time. More particularly Rule 7(1) of the general rules. Then if I may take your Lordship to paragraph 6.
Yeah.
From a perusal of page 18 of the OA, it is noted that one letter dated 1/7/11 was issued by Mr. M. Kalita, Assistant Administrative Officer, in charge on the subject surrender of residential quarter number 2, type 4, whereby it was conveyed the approval of the competent authority regarding surrender of the applicant's allotted quarter number 2. Now, 7, the applicant makes a prayer for release of her HRA, which was not appreciated by the authority. Now, the only point which falls for your Lordship's consideration is
the authorities had the accommodation facilities. The applicant, the respondent herein on her own, opted to shift to her own flat. Now, under the rules, HRA will be applicable, will be payable only to those persons where they are entitled to accommodation. They have not been given the accommodation. Here, accommodation is available. She surrendered the accommodation and then moved out.
All the things is whatever we think that it is 270 million, because
Which is that provision which says that in case the accommodation is available, if the government employee is not opted for that or surrender that government accommodation, that he is not entitled. If I may take your lordship to page 44. Page 44. Yes, lordship. Yes. The grant of house rent allowance shall be subject to the following conditions. A1, to those government servants who are eligible for government accommodation, the allowances will be admissible only if they have applied for such accommodation in accordance with the prescribed procedure, if any, but have not been provided with it in places where, due to availability of surplus government accommodation, special orders are issued by the Ministry of Urban Development from time to time, making it obligatory for the employees concerned to obtain and furnish no accommodation certificate in respect of the government residential accommodation at their place of posting. In all other places, no such certificate is necessary. Just a minute. So whereas those order of the Ministry of Urban Development from time to time, making it obligatory upon the employees concerned to obtain and furnish a no accommodation certificate. Where are those orders? Lordship, in fact, I have not annexed, but if I may take your. Annexed, then it's okay. If I may take your lordship. Of any such order, how can you ask since the government accommodation is available and therefore that is not fair. No. If I may take your lordship for a moment to page 68 also. Yeah. This is an office memorandum dated 14/11/2007. Yes. The first paragraph, lordship. Yeah. In supersession of this director is OM number so and so, dated 15/11/2002. The undersigned is directed to say that HRA Rule 4A1 issued by the Ministry of Finance, OM number so and so, dated 27/11/65, stipulates that the government servants eligible for government accommodation will be paid HRA only if they have applied and have been denied government accommodation at places where government accommodation is more than the requirement as declared by the Ministry of Urban Development. From time to time, the government employees need to furnish NAC issued by the jurisdictional estate manager to enable them to draw HRA.
NAC means?
Non-availability certificate. Here, the case is otherwise, Lordship. There are accommodations available, Lordship.
No affidavit was filed. No affidavit was filed. Written statement was filed by the union.
An officer was called. An officer was called.
What do you mean by officer was called?
An officer was summoned to the tribunal, Lordship, and since he could not say anything. Order has been-
There's nothing then what to say.
No.
There's nothing to counter that. Then. Held a review petition before the CAT.
Lordship, at this stage,
Yes, at this stage only.
Lordship will give the liberty.
Yes.
My lord, lordship may kindly look into page 82 of the repetition method.
Eight?
It is my affidavit in opposition. Page 82.
82.
Yes,
Yes.
my lord, it is the office memorandum issued on 8/4/2019, my lord.
Yeah.
Lordship. My lord, in pursuance of Ministry of Finance, Department of Expenditure, OM number such and such, dated 5/3/2019, copy and closed. In supersession of this directorate's OM number such and such, dated 14/11/2007, it has been decided there. The conditions of applying the government accommodation and furnishing of no accommodation certificate by central government employees to become eligible for house rent allowance are dispensed with for all places in the country in respect of general pool residential accommodation. Under the control by Directorate of Estates, Ministry of Housing and Urban Affairs, central government employees will thus be eligible to draw HRA if they have not availed the facility of government accommodation. And for this, they will not have to produce any NSP.
Yes. Yes.
Lordship, yes, so this is a subsequent.
देखिए, this writ petition is filed by the appellant being agreed with the, by the petitioners being agreed with the order dated, judgment and order dated
Yeah, no.
15th of June 2016, passed in OA number 040/00367/2015, filed on behalf of the private respondent with a prayer to direct the authorities, to direct the petitioners to grant the house rent allowance to him from the date of surrender of the quarter dated 1/7/2011. Full stop. And it counsel for the appellant, petitioner has argued that the tribunal has not taken into consideration the fact that in case where the government accommodations are available and the employee on his own decided to not to avail the facility of the government accommodation, or after availing it, voluntarily vacated it, he is not entitled for the HRA without
furnishing a non-availability certificate issued by the competent authority. Full stop. Per contra, learned counsel for the respondent has submitted that the government of India has submitted that the Ministry of Housing and Urban Affairs, Government of India has already clarified the situation and has provided that a central government employee is entitled for drawing HRA even though if non-availability certificate is not produced, full stop. The office memorandum dated 8/4/2019 dispensing the condition of furnishing no accommodation certificate is reproduced here under this it should be orange flag there. In view of the fact that the Ministry of Housing and Urban Affairs has already dispensed with the condition of furnishing no accommodation certificate for admissibility of HRA, we don't find any illegality in the impugned judgment passed by the CAT, hence this writ petition is dismissed.
Item 56.
Sorry. Safety because food.
I know. Where to compare with the safety method. Even with here, does not- Yes, now you have a mechanism in place.
Lordship, we have taken all the steps, major corrective measure, Lordship. Lordship, we have stated so in paragraph 12, Lordship, all the gadgets that is in the nature of extensometer, piezometer, magnetic extensometer, crack meter, tilt meter, inclinometer, and Lordship is given the data after this incident, how the landslide has been reduced, Lordship. Prior to that, Lordship will find at page 51, Lordship. That is 232, running page 232. The landslide data, Lordship. Till 2014, Lordship, total landslide was for 11 in 11 years is 654. In average, that is around more than 60 per incident of landslide per year, Lordship. After this, Lordship, next page, Lordship, page 234. In 8 years, total landslide incidents are 170. So in average, it is 21 per year. So it had been reduced. But what happened in the Lordship in 2022 June, Lordship find from the rainfall data, Lordship, page 235. In the month of June, Lordship, there was 1916 millimeter, Lordship, of rainfall in the recorded in June itself, Lordship. Otherwise, the average per month is less, it's around less than 3,000, Lordship. Beside, we have engaged watchmen and all, Lordship. And the lines were opened in 2015 only after getting approval from the railway board. Sanction was obtained, Lordship. That will Lordship find at page 203.
Lordship, this public interest litigation was filed in the year of 2022. At that time, there was a massive landslide in the.
2022.
Yes.
Yeah.
At that time, there was a massive landslide in the railway line. And accordingly, the South Assam zone was disconnected, was almost isolated from the rest of the country.
Yes.
And the purpose of this filing is PIL was to ensure the passenger safety. And at that time, that my learned friend have submitted very nicely, as explained, that they have taken adequate measure to prevent the landslide to ensure the safety of the passenger. It's good, well enough.
Yeah.
But we are in the 2024.
Yeah.
And this affidavit is filed in the 2022. If they have taken an effective step, then why this thing is happening again?
When
This
it has
time,
happened? When it has happened?
Since last 15 days,
Yeah.
since last 15 days, there is the train communication has been disrupted. And again, the valley almost has become isolated.
Today also it is almost disconnected.
Today, they have resumed certain trains since last 2 days, but it is a 6 to 7 hours journey from Silchar to Guwahati.
Yeah.
Now it is taking almost 24 hours.
So where are those datas?
Those,
Have you placed anything regarding these recent incidents?
this recent incident is reported in the different media. If
Sir, we are not, you suppose us that we go through all the media reports and
No,
then we,
Lordship, I'm not on that.
then
I'm not
place
on
it
that.
on record.
I'll
It is your
bring,
duty.
and Lordship, this basically, I don't to argue more on this issue because this matter is involves a lot of technicality. And being a lawyer, I can understand the technicality which they have explained and
No,
they have.
you please also understand that we are also not technical persons. Here we are also a layman like you. And so don't expect us that we to go into all these technicalities and put our knowledge into it. We are also not technical persons, sir.
One thing, Lordship, can be done if my friend is agree with me that they may send one fact-finding team on the spot.
Sir, you please place on record.
Lordship,
Then we
Lordship.
pass orders
Lordship.
like this. Why don't you
Lordship,
place
may-
on record whatever you want to say?
Yes, Lordship may fix a date within 7 days. I will bring all the
Okay.
information on the record.
Okay, this writ petition is filed in the public interest in the year 2022, raising a grievance that the railway authorities has failed to take CRS safety measures for the passengers who are willing to take the train route from Guwahati to Silchar. Full stop. Several instances of landslides and derailment has been mentioned, has been elaborated in this PIL petition. Full stop. A reply, a counter to the petition is filed on behalf of the railways, wherein it is specifically stated that the incidents of landslide happened in June 2022 were due to indecent rain, which is more than the average rainfall, which was more than the average of, which was more than the average rainfall. Full stop. In the counter, the railways have mentioned in details the effective steps and measures taken by it for preventing such incidents in future. It is also demonstrated that after taking those steps, the incidents of landslides and disruption in the railway operations has drastically reduced. Full stop. Learned counsel for the petitioner has submitted that recently, around 15 days before, on account of massive landslide, the operations between railway operation between the Guwahati and Silchar has been disrupted. He has been disrupted and till date has not been normalized. Learned counsel for the petitioner place some time to place additional facts on record. Time period for this granted list after 3 weeks.
Lordship is fixing a date for, within this time, I'll.
Date of choice of learned counsel.
Item 57.
Wait. Yeah, please, Lordship. Lordship, in this matter, Lordship, in fact, was interested to my colleague. There was a order, Lordship, to file a subsequent affidavit by the union because the honorable court was not satisfied with the affidavit that was brought on record. Lordship, I have not filed. I'm seeking some time to file that affidavit. But in any case, Lordship, I think the issue raised by my learned friend has been settled by the Honorable Supreme Court in a recent decision. That is Tamil Nadu and Puducherry Paper Cup Manufacturers Association versus State of Andhra.
Supply him a copy, he'll go through it and then argue it out.
I'll give him a copy, Lordship. In
If it is covered. It is covered, if it is not covered.
I have not gone through it. Let it come day after tomorrow, man. This is not reported. Right? Not reported. It is not reporting.
We'll see.
Day after tomorrow, let it come. If
After
it
a
is
week.
covered, in that
After
case,
a
we
week,
may
yes.
end then and there.
Covered in his favor or in your favor?
In my favor, Lordship.
Sorry.
After it is the plastic nylon.
Okay, we'll see to it. After a week.
Lordship.
Let it.
But